moments of whatever, like moments of chaos where they're trying to get us to quit, all of a sudden you'd hear
so I mean it just needs to be said though, I told that story to someone and that person just started saying it over and over and then it spread. So then everyone was saying it. I wasn't like, just randomly in buzz like, this is someone started and then it just spread. And then it's like,
All right, ladies and gentlemen, give me just a moment here. There's my background. Zoom tells me they signed me out of my Zoom desktop because I'm signed in on another computer. How I managed to sign in and then go somewhere else and sign on another computer while I'm sitting here is a good question. Do we have anyone here from the DA's office?
I sent a link to
I'm right
Brad
here, Your Honor.
Judge.
Oh,
Good
there's
morning.
Brad Thornton. Okay. All right. And Ms. Riley, I'm sure we'll need breakout rooms, so I'm going to make you the host and I will ask you to make me the co-host.
Okay.
All right. State versus William Clinton Sibley.
Good morning, Your Honor. Counsel's present. Mr. Sibley is in custody in the Atascosa County Jail. We have before the court a motion to dismiss with prejudice for violation of the interstate agreement on detainers. I anticipate the proceeding will take maybe 30 minutes at most.
Okay. All right. And is the Atascosa County Jail online? Not yet? Okay. All right. So let's try to get them online and I will mark you all 30 minutes.
Thank you, Judge.
Judge, my Zoom link is kind of acting weird this morning too. I came in as yourself this morning, so that might be the reason why it showed you were signed in twice. So I'm not sure what's going on. And I think I changed Eric Lipper's name to my name by accident a while ago. So I don't know if I have his name correct on there, Mr. Lipper.
It's now correct, Ms. Riley.
It is?
It is, at least on mine, but I appreciate the promotion.
Judge, and I just got with the jail on them signing in.
Thank you.
And Judge, I have two witnesses. I would say probably more around the 45-minute mark, but 30 to 45 minutes is accurate.
Right. All right, I'm going to call the civil dockets next in alphabetical order. I'll ask for announcements from the attorneys. Anyone who's present who either doesn't have an attorney or your attorney has not signed in, make sure I know you're here. San Miguel versus Peeler. How long today?
Your Honor, we have today that is Kiewitz motion for summary judgment. I'm expecting that will take 2 to 3 hours there, since there are only two parties arguing. But then prior to that, I think Mr. Lanfear wanted to be heard on his mediation motion.
Good morning, Your Honor. Mark Guthrie for the movement, Kiewitz Mining Group. I agree with Ms. Whittle on the timing.
Okay, so call that 5 and 180. 5 minutes on the mediation.
Your Honor, actually, this is Dan Lanfear for Justin Peeler. I believe we have an agreement on the mediation.
All right, is
So
it
it may just be-
Mr. Guthrie?
Yes, Your Honor, we agree.
Okay, excellent then. Just
San Miguel
text
agrees
me
as
and-
well, Your Honor.
Okay, all right, just
I can-
text me in chat and I will sign it,
Okay, so send a document to you in chat.
please.
Your Honor, we also have an agreed proposed order for the hearings on Tuesday. Would you like us to place that in chat as well?
Please. All right. Lena Salter versus Randall Gaidos et al.
That case has been dropped, Judge.
All right. Frio County, in the interest of Abel Ramirez, a child.
That
This is
case
the
has been dropped, Judge.
Okay.
All right. Used Cars Inc. versus Car Pro USA et al.
Morning, Judge. It's Guillermo Deckett for the movement. I believe Rick Crow's here. He is.
I'm present, Your Honor, for Car Pro and Elizabeth Rodriguez.
This is a reset of a motion for summary judgment, Your Honor. I think Mr. Crow and I spoke yesterday. I don't think it'll take more than 15 minutes, but we may need to confer. I'm not sure where things are at.
Yes, Your Honor. We were trying to work out a settlement. We hadn't mediated or anything, and on the previous MSJ, I filed a motion for leave of court and motion for continuance, and the judge just gave us a short amount of time.
That's
I
fine.
think that we could work something out.
I'll ask you to get with Ms. Riley after the call of the docket. She is the host now. She'll set up the chat rooms. Just report back when you either have something resolved or you're not going to. 21st Century Mortgage versus Santos Perez.
Your Honor, Dick McKinney for 21st. This is a motion for default judgment. It should take less than about 3 or 4 minutes.
All right, I'll mark you number 1. Karnes County, Adrian Opiella versus Intervest.
Good morning, Your Honor. Stephanie Cover here on behalf of the defendants Intervest. We're the movants in a motion to compel. Our estimate is 40 minutes in total, both sides. I don't know, Mr. Grissom's also here if he wants to speak to his time estimate differently.
Thank you, Your Honor. This is Don Grissom. I think it's probably more like 15 minutes. I think the issue is pretty narrow.
Okay, I'll put you in the list. All right, LaSalle County, matter of the marriage of Friesenhahn.
Present, Your Honor. Grady Roberts.
President, Your Honor, Abel Dominguez.
Okay.
Right. This is a motion to enter, I think it was said by the court, enter decree of divorce. But at this time, I would ask the court for just a little bit more time. there's been a difference of opinion about what the court ordered at the very end. We need to get a copy of the transcript, unfortunately.
Okay. What date was that? That was some time back, right?
Yes, it was in
Yes.
October, Your Honor.
It's done in October, Your Honor.
Okay, what day in October?
It was the 13th.
October the 13th, I believe.
But we just got the decree this week.
All right, I will look and see. I don't think I can still reach, get back from Zoom hearings that far back, but I will look.
Yes, Your Honor.
If not, you'll have to get that from court reporter. So do you want to leave it reset on request or?
Yes, please.
We've got the whole decree done, Judge, except for that.
For that one
Okay,
issue.
so do you want to get an entry date for sure and say you have to have gotten with the court reporter by then? And
As soon as we can, Judge.
Yes.
all right.
As soon as we can. We're ready.
Are we waiting for a date, Judge?
Thursday, the 4th, that's 2 weeks from today.
Yes, sir.
Thank you, Judge.
Thank you, Judge.
Yes, sir. You're excused.
Thank you.
Okay, BOFK versus Statwell.
Your Honor, I'm Eric Lipper. I'm here for the movement. It's a motion to quash and for protection. Travis Barton is on our side as well. I think 45 minutes.
Krista Castagnetta for BOKF. I don't think it will take that long, Your Honor. Let me also assert that Mr. Lipper and his team have been disqualified from representing Equinor in this matter. So we do need to take that up, and that's presented in our motion to strike their request for protection from discovery because it was signed by Mr. Lipper. Let me also mention, Your Honor, I have a hard stop at noon because I've got a plane. So
I'll get you before then. No, don't worry.
Okay, thank you very much.
I will ask if you're incredibly voluminous, if I could get a Dropbox link to copies of whatever motions or live pleadings I need to look at. And if they're not incredibly voluminous, if folks would post those to me in chat, I'd appreciate it.
I'll make sure that happens, Your Honor.
Thank you, sir.
Thank you.
LaSalle County versus Agapito Delgado III.
Good morning, Judge. Taxing authorities are ready to enter default judgment.
All right.
Judge, good morning. James Cabello for the intervener. We're ready to, Judge.
LaSalle County versus Jose Batroza.
Judge, that'll be the same announcement for the taxing authorities.
LaSalle versus Arcadio de Leon.
That will be dropped.
Okay. LaSalle versus Agapito Delgado III. Oh, I already called. I'm sorry. I'm sliding back and forth. I went too far. Hold on. I've got a new mouse and it's more sensitive than I'm used to. LaSalle County versus Ernesto Cruz.
That will also be dropped, Judge.
LaSalle versus Milicio Hinojosa.
Taxing authorities are ready to enter a default.
Green versus Department of Criminal Justice. Larry Wells from the AG's office. Mr. Green from Penitentiary, I believe. All right, I will recall. In re, the marriage of Candelario and Villa Elizondo. Okay, the Elizondo divorce, is anyone here? I see Candelario Elizondo on. I'm asking you to unmute.
Yes, sir, I'm here.
Okay. And are you ready to proceed?
Yes, sir.
Okay. I'll mark you A. I'll take you up after we do the uncontested matters with attorneys.
Okay, thank you, sir.
Wilson County, in the interest of Leah Alvarez, a child.
Judge, I show that the TRO actually has a setting for January 26.
Okay. Lori Quinn versus Ron Rickaway.
Your Honor, we're having some issues with service. If we could drop the setting and reset on request.
New Res LLC versus Francis Jefferson.
Hayden Hooper on behalf of New Res. Your Honor, I have not seen any response to our motion for summary judgment come through. The last contact we had with any of the heirs of Francis Jefferson was back in March of 2020. So I'm not aware of anyone else appearing on this. I'd expect the summary judgment, if it's just approved of, to take 10 minutes or less.
All right, I'll mark you number 2. And I'll also check with the bailiffs and make sure there's no one outside. The matter of the marriage of Glenn and Brandy Matula. Ms. Whitley?
Good morning, Your Honor.
Good morning, Your Honor. Abel Dominguez present for Mr. Matula.
Your Honor, Deanna Whitley for Brandy Matula. We think probably 2 hours. There's been a request for the court to interview a child. It's temporary orders in a divorce.
Correct, Your Honor.
Okay. All right. Well, we typically have a 1-hour limit on temporary orders, but I'll mark you for that. And sometimes if we go over, and I'm going to ask that you confer in a breakout room. And if you can't come to some resolution, I'm going to direct you to at least talk about what exhibits you might have, things like that. I don't want to have to stop a hearing later today so that the attorneys can look at each other's photographs of the family playing happily or something. I'll mark you 60 minutes. Anyone else told to be here today, your case was not called? All right, so let me go back and look. I'll do the uncontested matters and then take up the Sylvie case. I think that's probably the quickest. All right, 21st Century Mortgage versus Santos Perez.
Dick McKinney, Your Honor, for 21st Mortgage.
All right, I'm going to sign in to Frio County. Go ahead.
You want to go ahead, Your Honor?
Yes, sir. No, you go ahead, sir. I'm going to sign.
That's fine. Okay. Your Honor, I'm an attorney for 21st Mortgage. The motion for default is based on the affidavit of Brianna Smith. According to her affidavit, Mr. Santos Perez executed a manufactured home retail installment contract for the purchase of a manufactured home. He defaulted under the terms of that contract by failing to make his payments. He was given notice of the default and given an opportunity to cure. He failed to cure the default. And because of that, 21st has filed this lawsuit. In the lawsuit, they seek possession of the manufactured home, and they seek a judgment for the deficiency with the proceeds from the sale of the manufactured home to be applied to the judgment amounts. Both Santos Perez, who was the one that signed the contract, and Melina Tredino have been served. And Ms. Tredino has been added to the lawsuit because she's currently living in the home, and we try to give the people that live in the home notice of the lawsuit to Your Honor. So we're seeking possession as to defendant Melina Tredino. We're seeking attorney's fees of $1,000 for this default, $2,000 in the event of an appeal to the Texas Court of Appeal, and $2,000 in the event of an appeal to the Texas Supreme Court.
Okay, and I'm still trying to pull up the returns. And do you have an affidavit on your attorney's fees?
Yes, I do, Your Honor.
Okay. Right, let me see them.
Judge, all that paperwork is in the e-file. This is Dahlia from the district clerks, but it is with a coordinator right now. So if they want to send those papers so you can look at them. There's the
Okay.
affidavit, the default judgment and all that.
All right, I've just looked at one of them. Let me look at the other.
Okay.
Okay, they're fine. You use private process server. Okay, I will take judicial notice of the contents of the file. And your military service affidavits and such are all with the documents that were e-filed?
Yes, they are, Your Honor. Yeah.
Okay, assuming that's all in order, I will grant the relief prayed for, and I will look at those on the e-file queue later on today.
Okay, thank you, Your Honor. May I be excused?
Absolutely.
Okay, thank you very much.
Deanna Whitley, I signed you to breakout room 2, if you can accept that. Mr. Dominguez is in there for you, with you right now.
All right, in the matter of the marriage of Elizondo, Mr. Elizondo. All right, I'm asking you to unmute, sir.
Okay, yes, sir. Can you hear me now?
Yes, all right. Do you have your proposed divorce decree?
Yes, sir, I sure do. I have
Okay.
the final divorce of a degree of divorce and the original.
Okay. And how are you going to get that to me?
I have no idea, sir. I could mail it to you if possible.
All right. Well, it needs to, did you e-file this or you did it all by hand?
I did it all by hand, sir.
Okay. All right. Is that signed by your wife?
Yes, sir, it is. She signed it and then turned it in within, I think, 5 days of actually getting it.
Now, is that the decree or the waiver of site of service?
I
That she
don't
signed.
honestly don't know, sir. Let me kind of new to this. I don't know.
No, I understand. That's fine. She signed one document that I just pulled up and looked at on the LaSalle County District Clerk's Office, a waiver of citation or waiver of service of citation.
Okay.
So did she also sign a final decree of divorce?
There's one here with her name, but it looks like it's signed. Yes, sir. It's, I don't know if you can see this.
All right. I'm really going to need to be able to look at that, sir. So where are you right now?
I am in San Antonio right now, sir.
Okay. All right. And do you live in San Antonio? Do you live in LaSalle County?
Yes, sir. I now moved to San Antonio.
Okay. What I would suggest is that if you can make a very good scan of that final decree of divorce and send it to the district clerk, that's great. Even possibly get this done today. If you cannot, then I'd ask you to go ahead and just mail it to the district clerk or hand carry it down there, whichever, if you're down there during business hours. And that way, and then get this set in again, that way the judge can have it to look at, because the judge is going to have to sign it, and I really need to see what it says on there.
Okay.
Look at her signature.
Yes, sir. Do I need to take it to LaSalle or Frio?
It's filed in LaSalle, right? Yeah.
Yes, sir. It's filed in LaSalle.
Yes, sir. In LaSalle County.
Okay. All right.
Yeah,
Thank you.
just so you don't have to get reset a second time. Again, there's two different kinds of waiver of service that you can sign. One that says, Judge, I don't care what happens, just do whatever you want. And one that says, the only thing I'm giving up is the right to have the sheriff come and hand me papers. I want to have notice of all the settings. And that's this kind your wife signed. So if you don't have her signature on the filled out divorce decree saying that she agrees to all of the things in your divorce decree, then she has to be either present or you have to give her notice under the rules of civil procedure, which would be at least written notice, and that needs to be in a way that you can prove up, like it was by email or it was by certified mail return receipt requested. Okay, sir?
Okay. Yes, sir.
And how long have you been married?
Since 97, sir.
Okay, and have there been any children born to your wife since that day?
Yes, sir. We have 3 children, but our youngest is 20 already.
Okay, and she's had no other children?
No, sir. She has had no other children.
All right, the last thing I need to tell you is the law in Texas presumes that everything a married person owns is community property.
Yes, sir.
So it's not a matter of whether the two of you are fighting over it. It's not even a matter of whether it really is separate property. It could be something that one of you owned before the marriage or one of you inherited. But the law presumes that it's your community property. So if it's anything that's valuable enough, there might be a lawsuit over it one day. The divorce decree has to spell out either that it's community property and you're dividing it up, or that it's not community property. And if that doesn't happen, then the law presumes that you and your ex-wife still own it together, even though you're divorced.
Okay.
So if you have land, trucks, cattle, anything like that, you need to make sure a business, it needs to be spelled out in the divorce decree who gets it.
Oh, okay. We had 3 houses, but
It's right. I don't even know right now what it is. It's just, if there is anything like that, you just need to spell out who gets it.
Okay, yes, sir.
Okay. All right. I wish you good luck.
Yes, sir. Thank you.
Judge, and the jail is logged on already.
Okay, thank you. And Mr. Barrera had asked for a breakout room with him. Did he get that?
I'm fixing to put them in breakout room 4, Judge.
Okay. And let me log into Wilson County. Or actually, I think I've got the file right here. 19-8-630. All right, Mr. Hooper, on the New Res versus Jefferson case.
Yes, Your Honor.
Judge, I can confirm that no one answered when Francis, Jefferson, or any occupants were called.
Okay, thank you. All right, and you sent a copy to Albert Jefferson because he filed an answer that said he didn't know what was going on.
Yes, Your Honor.
All right, go ahead, sir.
Your Honor, I request that you take judicial notice under Rule of Evidence 201 of the contents of the file. We are requesting.
I will do so.
This request is ultimately based on a manufactured housing retail installment contract that fell into default. It came to our attention after the filing of this petition that decedent obligor Francis Jefferson died apparently on March 20th, 2010. Therefore, we sought a writ of scire facie on Albert Jefferson as a representative of the estate. That writ was issued and served on Mr. Jefferson, and he filed an answer, I believe, in February of 2020. We had a communication with him shortly thereafter regarding his desire to resolve this issue. A payoff quote was sent to the property address on March 31st, 2020, and we have not had any contact with he or any of the other presumed heirs since that time. At this point, New Res is relying on the evidence that has been admitted by the court and the affidavit in support filed by Kristen Maple on behalf of New Res, authenticating the documents and verifying the amounts that were due and owing as of the time this was filed. At the present time, we would ask the court to take those matters into consideration and enter a summary judgment. We are asking for the sum of $19,838.17 in actual damages at 7.25% interest, attorney's fees of $1,200 through judgment, $2,000 in the event of an appeal, and an additional $2,000 in the event of a successful appeal to the Supreme Court. Ultimately, it is my client's intention to foreclose and repossess this manufactured home, and with any proceeds derived therefrom to be applied to the outstanding debt.
Okay, and do you have your proposed judgment?
Proposed judgment was e-filed, I believe, Your Honor, along with this, the actual motion.
Okay.
Judge, I can upload it in chat.
That's good, thank you. And you're just asking for a judgment against the estate in rem on the mobile home?
That's correct, Your Honor. We don't have any non-in rem claims against any of the answering or appearing heirs. We're simply seeking a judgment against the estate and to repossess the mobile home.
All right, then I have taken judicial notice of the contents of the district clerk's file, and I will grant the relief prayed for.
Thank you, Your Honor. May I be excused?
Yes, sir.
Thank you, Judge.
All right, and Ms. Whittle, it's on your case, it's going to be a while. Let me see what else.
Yes, sir. Would you like us to report back a little later?
Say 1 o'clock. No, not Miss Whitley. I said Miss Whittle.
Oh, sorry.
Mary Whittle's on the Peeler case. They're
We
used
have
to be
similar names.
Okay, thank you.
1 o'clock.
Yes, Your Honor.
That's fine with KMG, Your Honor.
Okay. Okay. We'll
Thank
see
you.
at 1 o'clock.
Thank you.
All right, Ms. Tejada, I just sent the signed judgment to you.
Thank you, Judge. All right, used cars versus Car Pro USA.
They're still conferring, looks like. Excellent. All right, Mr. Sibley, are he and Mr. Barrera still in the breakout room? Okay.
Yes, Judge, Stephen Barrera and the Atascosa County Jail are still in the breakout room.
I'm gonna look at the Dropbox for the Equinor.
Your Honor, is it your plan to handle that criminal matter this morning or reset it to this afternoon or?
No, I was gonna try to get on it as soon as you're back, or as soon as Mr. Barrera is back.
Okay.
Okay, so everybody from the Equinor case is in the breakout room too, okay? Because the link they sent me requires that I have an account there. So let me do the order compelling mediation. All right, ladies and gentlemen, my laptop has begun playing the game it plays once or twice a week where it starts telling me that PDF files I am sent in Zoom are corrupted. And I know from experience that it's going to continue to do that until I reboot. So I am going to exit the meeting, reboot, and sign back on. That usually takes at least 10 minutes. So I shall return. Okay, I'm back. And before I forget, Mr. Guthrie, Ms. Whittle, if you're still on.
I think they
Yes, Your
left,
Honor.
Judge.
I'm trying to get back my
That's
camera
fine. I
going.
was just going to tell you that I had to reboot my computer because when I tried to download PDFs, they started coming across as corrupt and they couldn't be opened. The order on mediation, and if I was sent the proposed orders on the rulings from 2 days ago, they were corrupted. So if you or somebody when involved in the case would resend them, I would appreciate it.
We'll be happy to, Your Honor.
Thank you. All right.
Thank you.
All right. And Mr. Barrera, do you have a copy of your motion?
I do, Your Honor. Would you like me to forward that to your email?
If you could just post it to me in chat, I'd appreciate it.
Yes, Your Honor.
And
The Atascos County Jail never came out of the breakout room, FYI.
Okay. All right. You may have to go get them. Ms. Riley, you may have to join the breakout room and tell them to leave.
Okay, I'll go in there right now and ask them to.
Or am I the host? No, I'm not the host. Yes.
I can go in there, Judge.
Judge, I just asked them to.
Oh, okay. Thank you. And Mr. Barrera, what's the Code of Criminal Procedure chapter?
The article that we're looking at is Article 51, Your Honor. And then and Brad, I know you have a copy of my motion. I'm going to send you what I sent the judge just so you see what I sent him.
Sure.
All right. All right, and we're still waiting for Mr. Sibley's in Atascosa County now? I take it.
He is. I just conferred with him on Zoom, Judge. We were in a breakout room, and I guess he did not hit leave breakout room.
I think they're back, but he's not sitting in the chair, so I think they put him back to his cell.
Oh, they are back. Yeah.
I believe they said they had to go
Yes.
get him, is what the deputy said.
Judge Wilson, would you like me to check the process on Sibley and see if he's where he's at right now?
I'm sorry?
Hey, Judge, would you like me to check on see where the inmate is right now to make sure they're ready? I don't know why.
I don't know. Is someone said they're going to get him?
Judge, I just called booking and they told me they were.
Okay.
Okay. Thank you, Chris.
All right. So calling State versus William Clinton Sibley on the defense motion to dismiss. Are both sides ready?
State's ready, Your Honor.
Defense is ready, Your Honor.
All right. Go ahead, Mr. Barrera.
Here, let me make sure. Okay. Your Honor, what we have before the court today is a motion to dismiss with prejudice for violation of the interstate agreement on detainers. Mr. Sibley has a pending indictment in Atascosa County under cause number 18-02-0042-CRA. And Your Honor, I don't know if you have the court's file accessible to you.
I can log on and get it.
Okay, just because during the case, I am going to ask the court to take judicial notice of some things that are contained in the court's file.
Let me start the signing in process for Atascosa County. Go ahead.
Okay. And so while that case was pending, Mr. Sibley was incarcerated in the state of Michigan and was sentenced to a term of imprisonment. While Mr. Sibley was incarcerated, he was served with documents from the state of Michigan asking him whether he wanted to have his cases in Texas resolved within the time period permitted by the Interstate Agreement on Detainer Act. Mr. Sibley did execute those documents. Those documents were forwarded to Atascosa County. Our argument's going to be that Atascosa County at that point had 180 days to get Mr. Sibley over to Atascosa County for prosecution on his cases, and they did not. And so what we're going to be asking for, Judge, is the remedy that is laid out in Chapter 51 of the Texas Code of Criminal Procedure, which is dismissal with prejudice. Now, I don't know how the court wants to proceed. I have talked to Mr. Thornton. We do have exhibits attached to our motion. Mr. Thornton has agreed to stipulate to the admission of those documents, when we get into the actual proceedings. I'm assuming we're doing opening right now, so.
Yes, and I'm getting a case pulled up.
And I just sent to both Mr. Barrera and to the judge through chat a copy of the capias of indictment that includes the warrant and the indictment, just for the record, if Mr. Barrera wants to review that and see if he stipulates that the judge can use that copy of the indictment.
It's downloading.
All right, it looks like you made a notice of appearance on October 14th, something like that? Yeah.
Yes, Your Honor.
Okay. And the documents you're referring to that would have come from the Michigan Department of Corrections, are they in the clerk's file?
They are not, Your Honor.
Okay. All right, go ahead, Mr. Barrera.
And I don't know if the state, if Your Honor was just hearing opening, that's basically my opening.
Yes, I would just, just open.
Okay. So, Your Honor, the state has indicated that they're willing to stipulate to the documents that are attached to the motion. So I just want to go through them briefly. In Exhibit A, page 1, Your Honor, you're going to find the letter that Mr. Sibley receives notifying him of the information that was going to be sent out to the prosecuting attorney in the state of Texas. Page 2 is going to be Mr. Sibley's verification of incarceration, which shows that he is serving a sentence in the state of Michigan. On page 3, you're going to see that Michigan notifies Texas Department of Criminal Justice that Mr. Sibley is incarcerated in Michigan and that he has executed forms that pertain to the interstate agreement on detainers. On page 4 of Exhibit A, there's a letter to the Atascosa County clerk, which says enclosed are copies of the forms 2, 3, and 4 for the interstate agreement on detainers. Also enclosed is a copy of a letter to your prosecuting officer. The prisoner has requested speedy disposition of all charges. That's on May 27th of 2020. On page 5, there is a letter that is sent to the Atascosa County Attorney's Office informing them that there is an inmate in the state of Michigan who has pending felony charges in Atascosa County, and that he has demanded a speedy disposition of all charges by signing the Interstate Agreement on Detainers Form 2 Waiver of Extradition. And then on Exhibit B, you're going to see the actual documents that Mr. Sibley executed in order to get this process started. He did request disposition and speedy trial on his matters. He did waive extradition on this matter. If you go to page 2 of Exhibit B, there's a notice to the Atascosa County Attorney's Office, which was executed by Mr. Sibley on March 27th. If you go to Exhibit C, that's the verification of prisoner status, which is sent over to the Atascosa County Attorney's Office as part of the packet. Exhibit D, you have the Michigan's offer to the Atascosa County Attorney's Office, to Atascosa County, to surrender Mr. Sibley to the custody of Atascosa County. on page 2 of Exhibit D, they attached the capias showing that Mr. Sibley does have a hold out of Atascosa County. And then on Exhibit E, you're going to see the what we call the green cards or the returns, showing that the packet was served, was sent from the Cotton County or Cotton Correctional Facility in Michigan to both the Atascosa County Clerk and to the Atascosa County Attorney's Office. They were signed for on April 3rd of 2020. And that's the evidence that we intend to rely on in order to make our case, Your Honor.
And without stealing Mr. Thornton's thunder, I noticed that, I mean, Lucinda Vickers is not here because it's not her case. So when was the district clerk or the district attorney's office notified of all this?
So the issue that you have with this statute, Judge, is one, under Article 5114, the Interstate Agreement on Detainers, if you go to Article 3, subsection B, it says, the written notice and request for final disposition referred to in paragraph A hereof shall be given or sent by the prisoner to the warden, commissioner of corrections, and other official having custody of him, who shall promptly forward it together with the certificate to the appropriate prosecuting official in court by registered or certified mail return receipt requested. So under the statute, the responsibility for forwarding these documents to the prosecuting agency is on the correctional facility, the warden, the commissioner of corrections, the officials having custody of him. If you look at...
And Your Honor, before we get real deep into the legal nuances of the argument, I have Miss Maureen Arnold here to testify from the county attorney's office about, she's with the attorney and she's in charge of handling the mail about the receipt of this. I'd at least like to make a record so we can at least have that in the facts before we get too deep.
Let me withdraw my questions then and let you do your opening, and then, I mean, Mr. Barrera would get to call any witnesses he has first.
That'll be fine, Judge.
And I would ask Mr. Barrera if he would agree with just letting me call her out of order because she's in court right now, and I'd like to let her get back because it's very, very quick what I just have to ask her.
That's fine, Your Honor. We have no objection to that.
May I, Your Honor?
Raise your right hand. Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I will.
Okay, and your full name?
Maureen Arnold.
All right. Go ahead, sir.
Ms. Arnold, who do you work for?
Lucinda Vickers, County Attorney.
And what's your job title there?
I'm the office manager.
Okay, and as part of your duties as the office manager is to receive and distribute mail within the office?
That is correct.
Okay, and where do you get your mail?
There's a kiosk out back that we have a key to. The postman puts the mail in there and then we open our box and we get the mail.
Okay, and when it comes to certified mail, with the little green cards that you receive and have to sign for, where do you get those?
We don't get them. We get the mail and it has the green card torn off, and we haven't signed for a certified return receipt in probably maybe a year and a half or more since we got the kiosk.
Okay, and that's not the way it's supposed to work, correct?
Correct.
Okay, what is supposed to happen?
Well, they're supposed to bring the mail and we're supposed to make sure it goes to our office. We sign for it, give them the card back, and they go on their way.
Okay, now prior to your testimony today, I sent you an email with the exhibit that the defense has provided, which I believe he referred to earlier as Exhibit E, which is the mail cards.
Yes.
That were signed for by the county attorney and the county clerk in this case. Have you reviewed those?
Yes, I looked at them.
Okay, and the signatures on those, are those the signatures of anybody within your office?
No, sir.
Okay, and is that the same signature that you see repeatedly, somebody having signed for your office and placed them into that mailbox?
Yes. Well, we don't get them, so I don't know that name. That name does not ring a bell. And by the time I get it, the card's not there. So I can't really say who's signing, but the postmaster is the only one that has a key to the back of the box. And I'm the only one that has a key to the mailbox itself. So
Okay. If you did receive a document requesting extradition that was on a case that wasn't yours, what would you do with it?
well, first I would look it up to make sure it wasn't our case. I would see that it's a felony case, but I would ask all my attorneys, hey, are you expecting this? If none of them said that it belonged to our office, I would call the person that mailed it and ask them where it was meant to go, and then I would deliver it to that office.
Okay. And do you have any recollection of receiving a basically an extradition request from the state of Michigan for Mr. Sibley?
No, sir. I would have remembered that. It's not a normal piece of mail that we get. I would have remembered that.
And okay. So to your recollection, you have not received that or distributed?
No, sir.
And you are the sole person who distributes the mail in the office?
Sometimes the bailiff will get it because they have packages in our box. Every once in a while, Polly will get it, but 98% of the time it's me.
Unless there's a very unusual circumstance.
Correct.
Okay. I'll pass the witness.
Go ahead.
Thank you. So any document that is served on the Atascosa County Attorney's Office that is sent certified return receipt requested would have the signature of J. Valle, whoever that is.
Correct. Or whoever's
You've
working the mail that day.
Okay, you've seen that signature before.
I have on the paperwork that y'all sent me, but I haven't seen it because we don't get the green card. It's always gone off the mail.
Let me ask you this. Certainly at the Atascosa County Attorney's Office, there are important documents that are coming in, some of which may be time sensitive, correct?
That is correct.
Okay. Whose responsibility is it to, maybe talk to the postman or have a conversation to basically say, hey, you're not to sign for these things for our office. We should be signing for them.
I honestly don't even know. I mean, I guess it could be me or Lucinda.
Okay.
When we get expunctions in the mail all the time, and the cards are all ripped off, and I just handle the expunction. It never dawned on me that stuff was being signed for that we didn't receive. And of course, I don't know what's coming, so I don't know what we are not getting.
Well, so with regard to, you said that this practice of somebody signing for you guys and you don't know who it is has been going on for 1.5 years, right?
Right.
How did it work prior to that?
They would come to, we were in the courthouse before that. They would come to our office and have us give us all our mail and sign anything we needed to sign. Once we moved over here, the postmaster told me that we were grandfathered in over at the courthouse and they were supposed to come to each office. But here they were not going to do that. They wanted a central place set up to where they could deliver the mail and packages to that central place. They were not going to go to each office. So we had to have it installed.
Now, if somebody was mailing something to the Atascosa County Attorney's Office, and in the address box, they put Atascosa County Attorney's Office, 1 Courthouse Circle Drive, Jourdanton, Texas, 78026, that's the correct address for the Atascosa County Attorney's Office, correct?
No, it is not.
Okay, what is the correct address?
1405 Campbell, Suite 103. We've been here since December 17th of 2018.
Okay, would it surprise you to learn that your address as listed on Google, if somebody Googles you, is 1 Courthouse Circle Drive, Jourdanton, Texas?
No, because when you look up the Atascosa County District Attorney's Office, it has our phone number. So no, I'm not surprised.
Okay. Do you ever mail that is listed as 1 Courthouse Circle Drive, Jourdanton, Texas, addressed to the Atascosa County Attorney? Where does that go? Does it just get lost or destroyed?
They put it in our box. Sometimes people at the courthouse will say, hey, I got mail for you. Okay, and I go get it.
Okay, okay. So, and certainly on this card, it appears that somebody has signed for it saying that whatever this was delivered on April 3rd of 2020.
Correct. That's what I saw.
Okay. With regard to mail that you get, you said that, hey, if I get mail and I don't know what it's for, I start asking around. If you received mail addressed to Lucinda Vickers stating that somebody in the county had a felony pending, what would you do with that mail?
Most likely I would call the DA and ask them if it was supposed to go to them. We get mail for them frequently.
Okay. When were you asked to testify at this proceeding? How long ago did you find out that this proceeding was going on?
The other day, one of my coworkers asked me if I saw that card and who that was. And I said, well, it's probably the postman because we don't get the green cards. And so that's how all this started. I believe Mr. Cavazos was talking with Miss Filson from our office, and that's how it started.
Okay. Did you all have a chance to look in your office to see if that package or that mailing could be located?
Yes, we did, but it's not here.
Okay. Okay. And it's fair to say that just because you guys didn't find it, that doesn't mean it never arrived, correct?
I don't recall seeing that, and I would have been the one to get it.
Okay. So essentially, the court would have to be of the understanding that the postman or whoever delivered it signed for it, but sometime between signing for it as delivered to you guys and you guys actually receiving it, it somehow disappeared.
Well, you're assuming that he put it in the correct box. I get mail for the judge. I get mail for the district.
And that would be the problem with having the postman sign for legal documents, correct?
Exactly.
Because
exactly.
certainly if we were in a situation where you guys were signing for documents as should be done, we would have a signature from somebody in your office.
Correct.
Okay, but that's not the practice.
Not lately, no. Not for the past 2 years since we got that kiosk out there.
Okay, I'll pass the witness.
No more questions, Your Honor.
All right, may this witness be excused?
Yes.
Yes.
Go ahead, Mr. Barrera.
Your Honor, what I have at this point is basically arguing the law and the facts. And so I have no further evidence on this issue at this time.
Then, Your Honor, I would need to call Major Miller.
All right.
With the sheriff's office.
All right, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Good morning, Major. Can you please state your full name for the record?
Yes, it's Matthew Miller.
And how are you employed and who do you work for?
Atascosa County Sheriff's Office. I'm employed as a major.
And as part of your responsibilities, are you in charge of the prisoner transport division at the sheriff's office?
Yes, sir, I am.
Okay, so if there was a bench warrant where you had to go get an inmate or an extradition request, you'd be the one kind of overseeing that?
That's correct.
Okay. And how long have you been in that role?
For a year and a half now.
Okay, and so that would include back to April of 2020, correct?
Yes, yes, sir.
Okay. Now, are you aware of the coronavirus pandemic?
Yes, sir.
And has the coronavirus pandemic caused a problem with jails throughout Texas and the United States in terms of their ability to transport inmates between each other, as well as affect the restrictions that you guys have internally about testing and your ability to accept inmates to control the coronavirus within your facility.
Yes, in many aspects.
Okay. And that's something that you've been battling since sometime, probably preparing for since February or March of 2020?
I would say March of 2020. Yes, sir.
Okay. And in March, did the Atascosa Sheriff's Office restrict any transports of inmates between jails in order to control the coronavirus outbreak?
Speaking with the jail captain, yes, starting March through sometime in July or June or July, but I wasn't privileged to that information at the time.
Okay.
It was more of a jail issue.
Right. And it is your job to arrange the transports. So you did not arrange any transports between March and July, except for an extraordinary or at all between March and July?
Not that I can remember.
Okay. And even in July, the coronavirus still is a problem within the jail and something that you're actively having to fight and control, correct?
Continuing, yes, sir.
It's continuing up until present.
Yes, sir.
Now, as part of your duties, you've also been an investigator at the Sheriff's Office, correct?
That's correct, yes, sir.
And you're familiar with jurisdictional requirements for the County of Atascosa in terms of filing cases with the appropriate authorities, correct?
Yes, sir.
And if there is a felony in Atascosa County, which is the correct prosecution?
Mr. Thornton, Mr. Barrera, I'll be willing to listen to any objection, but I'll think I can take notice that as a matter of legislative law, the Atascosa County, the felony cases against adults are prosecuted by the district attorney. Misdemeanor cases against adults are prosecuted by the county attorney, and the law is a bit opaque as to who has responsibility on juveniles, but as a matter of practice, at present, they're prosecuted by the county attorney.
Okay, Your Honor. So we'd ask the court to take
judicial notice of that, Mr. Barrera?
I have no objection to that, Your Honor.
All right, go ahead, Mr. Thornton.
Then do you recall requesting the extradition of William Sibley in this case?
Yes.
And do you recall when that process started?
Not 100% sure. I know sometime in October is when I contacted personnel at the cotton facility in Michigan. Okay.
And do you recall when you were able to complete that task and he was able to arrive?
Yes, sir. Yes, because of the pandemic, it took until about November 26th. It was actually November 26th of 2020 when he arrived at our jail.
And were there some delays and difficulties in that process?
Yes, definitely. Yes.
And what were they?
Well, the main thing is to get out-of-state transports, we use a contracting company, and because of the pandemic, their resources were restricted. The states that they would actually travel in by either land or air were restricted depending on where the outbreaks were and the numbers. So that changed frequently, and they would update us with it. But then also trying to get him in a local sheriff's office to pick him up, so my contractor could get there. The sheriff's office denied picking him up because of the pandemic also. Stating that the prison system up there had a hard time controlling it, want to infect their inmates in the jail, which is understandable. Other than that, the contract company needed at least 2 weeks to schedule and be able to pick him up, and his release date was going to be too early at that point during the initial setup for the contract.
And do you recall what prompted your phone call to Michigan to begin this process?
Yes, I believe your office called. I believe you called me because someone from the cotton facility had called you. So you just wanted me to straighten it up and see what's going on, and that's where we started the process.
And so you returned the call from the voicemail that I received from Michigan, correct?
That's correct. Yeah.
I pass the witness.
Thank you.
Barrera?
Major Miller, you said earlier that because of coronavirus or because of COVID, you all were restricted in transporting inmates?
That's correct, yes, sir.
Okay. And you said that restriction was from what period of time to what period of time?
From March till June or July.
Okay. So if it's from March to June or July, so there was no restriction in August?
There could have been some restriction, but I'm not 100% because it changed over time depending on the numbers.
Was there a restriction in September?
There may have been, again, I would have to check emails and protocols. We have about 15 different COVID protocols from the beginning of March till now. So
when's the first time you recall Mr. Thornton getting in touch with you to tell you, hey, we have somebody that needs to be transported over?
I believe it was either late September, early October.
Okay. So Mr. Thornton did not reach out to you in April or May, correct?
Not that I'm aware of.
Okay, so it wasn't the case that Mr. Thornton reached out to you and you said, hey, look, there's a restriction on this. We just can't do it right now. You never had that conversation with him?
That was not an issue at the time, no, sir.
Okay. And that wouldn't have been an issue in May or June where he reached out to you and you said, hey, we have restrictions. I can't do this right now.
That may have been an issue there, yes, sir.
I'm sorry, you had a conversation with him in May or June where he asked you to bring?
I'm sorry. I thought you said if he had asked me back then.
No. I'm asking whether he contacted you during those months and you all had a conversation like that.
Not that I'm aware of.
Okay. When you had a conversation with him in September or October, did you say, hey, there's restrictions, I can't bring him over?
No.
You said essentially, okay, let me start working on this, correct?
Correct, I did.
Okay. And earlier you testified that you started working on it in October, right?
That is correct.
And Mr. Sibley was here the following month.
That's
in
correct.
November.
Yes, sir.
Okay. Now, with regard to transporting inmates, how long was the process in total from the time you initially made that request with the third party until Mr. Sibley got here?
I'd say no more than 6 weeks.
6 weeks. Okay. So from the time you made the request, Mr. Sibley was here within 6 weeks.
That's correct.
Okay. Were you the one in charge of getting Mr. Sibley over here the entire time, or was there anyone else that was involved in this?
Are you talking all the way back from when the indictment or the capias was?
No, from the time that the DA's office made the request, are you the point man on this issue? Are you the
Yes,
one
sir.
that appointed? Okay.
Yes, sir.
I'll pass the witness.
I have no more questions, Your Honor.
All right, any other witnesses?
Not from the defense, Your Honor.
No witnesses from the state. I do have 2 exhibits I would like to offer into evidence. Outside of that, I have no more witnesses.
Okay, what exhibits?
I just want to, and the court possibly could just take judicial notice of them, but they are the emergency orders from the Supreme Court and the Court of Criminal Appeals.
Your Honor, I have no objection to that. If that's the Governor Abbott's order that's been signed off on by the Texas Supreme Court and Court of Criminal Appeals, I mean, it's a standing order. I have no objection to that.
It's not the Governor Abbott's, it's the Court of Criminal Appeals and the Supreme Court joint order about deadlines.
Yeah, I have no objection.
Okay, and then without objection, they're admitted.
And I've sent those to Judge Wilson and Mr. Barrera, States Exhibit A and B through chat.
And I'll take judicial notice of all of the communiques from the Supreme Court and the Court of Criminal Appeals that are.
We'd ask you also to take judicial notice of the governor's emergency declaration as well.
And the governor's emergency declaration.
And Your Honor, we would have no objection to excusing Major Miller as well. We have no more questions.
All right, Mr. Barrera?
I have no objection to that, Your Honor.
And Major Miller, you are excused. Thank you.
Thank you, Judge.
All right, Mr. Barrera?
Your Honor, so with regard to this case, I mean, the issue that we have here is Article 5114 has a very specific timeline. And it says, look, you know, once the defendant avails himself of these requests for speedy trial, his waiver of extradition, this timeline starts. Now, the state does have the ability to come into court and say, look, we need a continuance. That 180 days, that's not going to be possible. The statute allows for that. The statute says state can go in and under Article 3, subsection A, it says that provided that for good cause shown in open court, the prisoner or his counsel being present, the court having jurisdiction of the matter may grant any necessary or reasonable continuance for good cause shown. And that's the issue that we have here, Judge, is that there was just absolutely nothing done on this case. I mean, all of these things that, you know, we're talking about are things that are coming up after the fact to say, you know, well, look, back then we did have good cause, but that's not what the statute calls for. The statute says within that 180-day time period, somebody has to come into court and say, hey, we just need more time on this. And these are the reasons. Now, to address some of the things that were brought up by the state, you know, one of the things that was mentioned was, well, we don't know if the Atascosa County Attorney's Office, you know, even got this packet. Judge, there's a green card, a signed return in the documents that shows that somebody signed for that package at the Atascosa County Attorney's Office. And I don't know that it's a proper defense to that. I mean, if I was serving somebody and, you know, and I had a return on a green card, but then the party said, well, I never got it. I mean, I don't know that that's going to be a valid defense, Judge. You know, the fact that the Atascosa County Attorney's Office may have had these practices in place that they shouldn't have, I don't know that that weighs against Mr. Sibley. I mean, the court would essentially have to say, well, you know, since the postman signed for them and they're saying they didn't get it, he's out of luck. And that's part of this is Mr. Sibley did everything he's supposed to do under the statute, and to say, well, you know, we don't know if they got it because even though there's a signed card, Maureen, you know, doesn't remember getting it or doesn't remember seeing it. You know, with regard to the issue of the fact that this is addressed to the Atascosa County Attorney's Office, I would submit to the court that if you're up in Michigan and you Google Atascosa County prosecutor, the Atascosa County Attorney's Office is going to pop up. Now, if you look at the documents that are in evidence, the documents in evidence, if you go to Exhibit B, page 2, where it gives the prisoner's notice and request for disposition of indictments, information, or complaints, Form 2 says to Lucinda Vickers, prosecuting official, Atascosa County, Texas, and to the clerk of Atascosa County, and to all other prosecuting officers in courts of jurisdiction listed below from which indictments, information, or complaints are pending. And so certainly if the argument is, well, Atascosa County Attorney's Office doesn't prosecute misdemeanors, the form says, you know, this document is addressed to any other prosecuting officials in that county who have jurisdiction over indictments, information, or complaint. And I would submit to the court that, you know, at that point, given that Atascosa County does have split offices with regard to prosecutors, unlike the Bexar County DA's office or you know, Kendall County County Attorney's office, I would think that there has to be some type of cooperation between the two offices to say, well, these documents are getting to the right place. I mean, even you know, Maureen testified that, hey, if we get something that is for a felony, we direct it to the district attorney's office. But I don't remember seeing that document. But to say that, well, you know, the officials up in Michigan whose responsibility it is to forward these documents, because under the statute, that's not Mr. Sibley's responsibility. According to the statute, that's the responsibility of the Department of Corrections in Michigan to forward these documents to the prosecutors. To say, well, because, you know, the offices are split, Mr. Sibley's just out of luck and none of this stuff applies to him now, that would seem to be a miscarriage of justice. The other issue, you know, with regard to this is the fact that even, you know, discussing some of these issues, like, well, in April, there were coronavirus concerns. You know, in May, there were coronavirus concerns, and so maybe the jail couldn't house them. The request wasn't put in until September or October. So it's hard to rely on this restriction on transport in April, May, or June when there was never a request made at that time. You know, the fact of the matter is, Major Miller testified he's not sure when that restriction was even lifted, but when the DA's office contacted him in late September or October, he got started on it. And Mr. Sibley is here within 6 weeks. There was no testimony that, in fact, the testimony was, we never got a request prior to that. There's no evidence that a request was made and they just couldn't simply get him over here. There was just never a request made. And so, you know, all of these things that are being pointed out are after the fact. It's not that this was an ongoing situation where it's, hey, we just can't get him here because of COVID. COVID is being cited after the fact as the reason as well. Even if had we made that request, there's no way we could have gotten him here in time. With regard to the issue of the governor's order and the Texas Supreme Court orders and things like that, those are good cause, Judge. And the statute says the state could go into court and argue those things, and those might be good cause, and the court would get to decide that. But the fact of the matter is that was never argued. This is the first time that the court is hearing this. That's not something that was argued prior to the expiration of the 180 days. Nobody ever filed a motion for continuance. If you look at the court's file, the last document in the court's file prior to my appearance of counsel is from 2018, and it's the capias. Nothing was done on this case from 2018 until I file my appearance of counsel. We got into court on this matter on January 8th, but that was because I placed it on the docket in order to present my motion. We reset that because I didn't give the state adequate notice, but the reason that this case is on the docket is because I placed it on the docket. The other issue that I would like the court to consider is, even if we accept the argument that, look, okay, you know, even though there was no request made in April or May or June or July or August or September, you know, by the time the request is made in October and he gets brought over in November, what happens then? Nothing. He doesn't get on a docket. He's not on a docket until I place him on a docket in January. If you look at the statute, what the statute says is that the dismissal is mandatory. If the state has not acted on the case within 180 days, the dismissal is mandatory. Now, the 180-day time period expired if that April 3rd notice, that return, that green card, if that's the date, we're saying they got notice. And I think in any court, that would be the appropriate date of notice, because that's when the receipt is signed by somebody as having received those documents at the Atascosa County Attorney's Office. If we use that date, The 180-day time period expires on September 30th of 2020. You know, as of December 10th, when we filed our motion, or as of December 10th, when I drafted the motion, 250 days had passed since April 3rd of 2020. As we sit here today, 294 days have passed since April 3rd of 2020. So we're not even talking about a situation where this is close, where it's like, look, it's 190 days, but COVID happened. We had some difficulties getting them over here. Nobody did anything on this, Judge. And I understand, you know, Mr. Thornton's position. You know, it may be, hey, we weren't aware of it. Whatever happened, Atascosa County Attorney's Office never sent it to us. You know, the postmaster never gave it to them. Something got lost in the mail or in transit, whatever it is. But you can't hold that against Mr. Sivley. Mr. Sivley did everything that he was obligated to do under the statute. The Michigan Department of Corrections did everything they were obligated to do under the statute. You can't take this situation and say, well, once it got to Texas, somebody dropped the ball, therefore he loses out on his rights under the Texas Code of Criminal Procedure. This statute is a mandatory statute. There has not been an argument of good cause within the 180-day time period. Everything is after the fact, Judge. So we would ask the court to take that into consideration and to dismiss these, set aside this indictment with prejudice, Your Honor.
Right. Go ahead, Mr. Thornton.
There's two main points. One is that the executive order and the Supreme Court order that allows, or actually says must grant extensions of deadlines doesn't place any requirement of when that has to be brought or when the judge has to rule that a deadline is extended. And so the state's position is one, that those deadlines are extended or should be extended based off of the coronavirus concerns addressed by Major Miller as a matter of law. And two, in order for the dismissal to be required and mandatory under the law, the service has to be proper. And Mr. Barrera has improperly stated the law when he has said that the burden is, the burden is on the Michigan Department of Corrections. Case law has actually said the opposite, that the burden is on the defendant himself to make sure that that is properly served. And not only was it not properly served to the correct address, it was not served to the correct prosecuting officer, nor the correct court. And both of those are required, the court and the prosecuting officer. And service will, even if they were the correct prosecuting officer, which they're not, service isn't proper because one, they were never signed for and delivered and never received by the agency, Lucinda Vickers' office. And so the state would like to present the court with a case. I'm pulling up now, I'm gonna post in chat, which is Lindley versus State. And I'm sending that to Mr. Barrera and to Judge Wilson through chat. Which is from the 7th Court of Appeals in Amarillo, which was decided in 2000. The site is Lindley, Lindley versus State, 33 Southwest 3rd, 926. In that case, the defendant had served upon the criminal district attorney the document, but there had actually been a special prosecutor appointed and the special prosecutor was not served. And the court said that the defendant's burden is to comply with the statute. And whenever a special prosecutor is appointed, they are the prosecuting officer and they have to be served. And so even in that extreme case of a appointment creating a new prosecution officer, the courts held that that wasn't proper. Now, in that case, there was knowledge on the behalf of the defendant because that prosecutor, I think, was his defense attorney. So they argued that he would have had to known he couldn't prosecute him because of a conflict. But even in that extreme case, the court said the burden is on the defendant. And that is a trend that you see throughout all case law concerning this, is that it's the defendant's responsibility. And down on the bottom, it says the failure of one, in the holding in the last paragraph, right after head note 10, it says the failure of one state to comply with the requirements does not require the dismissal of charges in another state. So if it was in fact Michigan's fault for sending that to the wrong agency, that does not require dismissal in the state of Texas, just because they made the error. The burden is on the defendant to correct that, to get it to the right place. And we were not served. And so because we were not served, that's why the procedures did not begin to take place until we got notice that he was paroling out of Michigan in very late September. And as an officer of the court, I'll represent that I started those procedures on September 28th upon a phone call and of contact with Matt Miller and with the sheriff's office. And everything was done as quickly as possible, beginning with that point. And he arrived on September 26th of 2020. Now, we believe that we did not start these procedures based off of the interstate agreement on detainers. If we had, then the deadline would actually be 120 days. And that would begin the date that he arrived here, which would be on November 26th. And the 120-day deadline would happen, of which 56 days would have passed. So
and that's the difference when the state requests transfer of the prisoner first.
I'm sorry?
It's 60 days shorter, the deadline, when the state requests transfer of the prisoner.
Right.
First.
Yes, it's reduced.
Not just a hold, but actually.
Transfer, right. And so we would not, that deadline would not have passed. And we would be asking, obviously, for a continuance for trial based off of the COVID requirements and the fact that the Supreme Court has ordered that there be no trials unless certain conditions are met, of which this court can take judicial notice of its policies with relation to the beginning of jury trials, which has not begun yet in this jurisdiction. And so we don't believe, one, the requirements were met of service, and we don't believe that even if they had been met, that the dismissal should occur based off of the Supreme Court and the governor's orders related to the coronavirus pandemic. And then third, we are now requesting continuance going forward at this point for trial based off of those coronavirus concerns.
All right, Mr. Barrera.
Your Honor, so a couple of things. One, with regard to this case, what the case says is that it says, and whereas here a criminal defendant has specific knowledge of the identity of the prosecuting office, the Attorney General's office, becomes especially more incumbent upon the out-of-state criminal defendant to ensure compliance with the statute's dictates. There's no evidence here that Mr. Sivley would have specific knowledge about the appropriate prosecuting agency. If you look at the subsection B of the statute under Article 3, it specifically says the written notice and request for final disposition referred to in paragraph A shall be given or sent by the prisoner to the warden, commissioner of corrections, or other official having custody of him, who shall promptly forward it together with the certificate to the appropriate prosecuting official and court by registered or certified mail, return receipt requested, which would seem to place that burden on those officials. And the other thing, like I said, the documents themselves address the notices to Lucinda Vickers and any other prosecuting officers in courts of jurisdictions from which indictments, information, or complaints are pending. You know, this court or this case that Mr. Thornton cites to is from 2000. I don't know how the statute has changed since that time. But Judge, again, these documents say this document is addressed to any prosecutor who has any pending indictments out of this county with regard to this defendant, okay? So just to say, well, we didn't see it because, you know, we don't know that the county attorney's office got it. Judge, it just doesn't work that way. I mean, it's all the state. I mean, the county attorney's office, the district attorney's office, they are the prosecutors for Atascosa County. To be able to kind of hide behind the fact that the offices are split, would seem to be an injustice on this matter. And the other thing is, like I said, I mean, there was nothing done on this. This wasn't a situation where people were trying to get things done and, well, we just fell a little short because of COVID or because of this issue or because of that issue. There was absolutely nothing done on this. Even once he got here at Thanksgiving, nothing's done on it. We're only here because we filed our motion. We're not here because of any sense of urgency, you know, good cause. There's no motion for continuance on file from the state at all in this matter. Not, you know, the day after he gets here on Thanksgiving or in December, beginning of January, there's no continuance, there's nothing. So there's never been an attempt by the state to say, well, look, all of these things that we're arguing here today are good cause, and therefore we're entitled to a continuance under this statute. So there's no attempt by the state to say, well, you know, there is good cause in this matter. The state is of the opinion that, well, you know, we never got it. So therefore we have no obligation to act, you know, on this cause. You know, we filed this motion December 22nd. We served this motion on the state at the beginning of January. There's no continuance. There's no attempt to address, you know, our claims under the, you know, interstate agreement on detainers. I mean, there's just nothing. I mean, the defense is simply, well, we didn't see it. And even had we saw it, there was good cause at the time because of COVID. Judge, my argument would be it's too little too late. Nobody tried to do anything on this case. The state was content to allow Mr. Sibley just to remain in custody with nobody addressing this. Nobody took a look at it. And even if we, you know, concede the fact that maybe Mr. Thornton didn't see it, that's not on Mr. Sibley. I mean, it's not on Mr. Sibley that the county attorney's office, you know, doesn't keep up with the mail. It's not on Mr. Sibley that even though the documents say this is addressed to the prosecutors who have jurisdiction over these felonies, that it never made it to Mr. Thornton. He did what he was supposed to do. And so we're asking the court not to strip him of his, you know, what he's entitled to under this act, Judge. We're asking the court not to take that away from him. The dismissal is mandatory, and we're asking the court to follow the statute.
All right, I've listened to the evidence very carefully. Mr. Brewer has made some excellent arguments. I want to state that, I mean, the county attorney's office can do with their mail whatever they want, but there's a presumption of receipt by the county attorney's office there. And I don't think that's overcome simply because they've got some system set up where they don't actually sign for their mail. However, the statute requires that the prosecutor and the court having jurisdiction both be notified. I don't have any evidence before me of when the court was notified, and I'll find that the county attorney's office is not a surrogate of is not the proper prosecutor, and they're not a surrogate for the proper prosecutor. There's several cases in Texas going back to at least Shin versus State in 1988, 744 Southwest 2nd 370, that hold that there has to be a rule. Either the error of the sending state is charged to the receiving state or it's not. And the law in Texas is that the sending state's error is not charged to the receiving state. And I think that Mr. Sylvie's remedy would have been to get the folks in Michigan to send it to the correct prosecutor. And if they failed to do that, I mean, I think he could mandamus them for that. But he doesn't have a right to be dismissed in Texas. Now, whether it's 180 days, there's also, because I don't have that in front of me, but there's a lot of case law in certainly other states, and I think some in Texas, that says actual receipt of notice by the prosecutor's office cures any problem in getting that notice to the prosecutor's office. So there is at very least a timeline ticking away. So y'all need to be cognizant of that. And on October 30th, we filed and very shortly thereafter got approved the permission to have jury trials in Atascosa County. Again, we'd have to resubmit that for approval on a per trial basis, I believe up to Judge Harrell, and get his approval for it, because we're not allowed to have jury trials generally. But if this is something that Mr. Sibley is really anxious for, then you can look at the rules and you can waive any objection to proceeding under the COVID rules. And if he has objections in the proceeding under the COVID rules, I think he would be unable to stand trial, and that tolls the statute. But again, that's not before me. But for right now, I will deny the writ of habeas. I'll take this as a writ of habeas corpus or motion to dismiss on the grounds of not following the 180 days, because I don't find that the time limit started to run until at least September of last year.
Your Honor, in light of the court's ruling, you know, certainly what happened here is it's an issue where the request maybe didn't get to the correct prosecutor's office or to the correct clerk. Mr. Sibley is currently being held on a $200,000 bond. He has been detained this entire time since he was brought over. Again, he's continued to be detained without anything having happened on his case. We would ask the court to consider reducing Mr. Sibley's bond. Mr. Sibley was actually out on a PR bond on the other two counts. This count was added by the state at the time of indictment, and bail was set at $200,000. We would ask the court to consider reducing Mr. Sibley's bond amount in light of the facts that were just presented to the court.
Okay, and has he completed whatever obligation he owes to Michigan?
He is on parole in the state of Michigan.
Okay.
Your Honor, I'd like an opportunity to have a hearing on that.
I'm about to say, I know what the DA's response is going to be, that they don't have a notice. So just set that, and yes, we'll hear it and consider it. And I take it, was there ever a NISI in this case, or Mr. Sibley was in custody elsewhere before his case came up? Because I didn't see, when I just went and glanced at the record, I didn't see where it said that there'd been a NISI call.
Your Honor, I'm sorry.
What had happened was when he was initially arrested, he was arrested on 2 counts, which I believe are counts 2 and 3 in the indictment. And then upon presenting that to the grand jury, I presented an additional count, which was count 1, which was the aggravated assault. And so a capias of indictment was issued on count 1, but not counts 2 and 3. And so that's what was served on Michigan, and that's all he's being held on now. I don't believe a NISI was ever issued on counts 2 and 3. And so
what's odd is in the court's file, there is a notice of setting, which was sent out to Mr. Sibley, but then there's nothing indicating what happened once that case came up on the court's docket at that setting.
Okay. All right. Well, I guess so. He's out on. So he has a PR bond on 2 counts and a $200,000 bond on another one.
Yes, that's right.
Okay. All right, get your motion filed, Mr. Barrera. We'll hear that as soon as possible.
Yes, Your Honor.
All right, anything else?
Nothing from the defense, Judge.
No, Your Honor.
All right, then y'all are excused.
Thank you, Judge.
Thank you. All right, Ms. Cavazos, do you need a break?
Yes, Judge, just for a few seconds.
Okay, and we'll come back, call it 11:15.
Okay, thanks.
All right, Mr. Rocha. I got off. I should have done the tax cases. Are you ready on all of those, Mr. Cabello?
Yes, Judge, I am.
Okay. All right, go ahead, sir.
Judge, would like to motion to consolidate for proof for the three tax cases we're ready to enter default judgment on.
No objection.
I'll order it.
Also, Judge, if you could take judicial notice of the court's files of the good service on the individuals on today's tax docket.
I'll take judicial notice of the entire contents of the court's files.
Thank you, Judge. The taxing authorities would also like to enter into evidence the certified tax statements that we will include with the judgments when e-filed as the prima facie proof of the delinquent taxes that are currently due for both the plaintiffs and also the interveners, please.
No objection.
Without objection, they're admitted in each case.
Judge, also, we'd like to enter these judgments and proceed to tax foreclosure if the individuals do not set up any type of payment contract with the taxing authorities.
I will order that.
Thank you, Judge. That's all we have for today.
Yes.
Okay. All right. I will, and you've e-filed your orders?
We will process those, we will e-file those today, Judge.
Okay, and since last Friday, I have had access to the district clerk's records in LaSalle County. And if you had anything in the judge's queue, I had stuff as old as October, but it's zeroed out as of yesterday. So I'm able to work on all 5 counties from my desk. So, all right, you are excused.
Thank you, Judge.
Thank you, Judge.
All right, Opiella versus Intervest, are we still conferring?
This is Don Grissom. I'm here.
Stephanie Cover, here for defendants, Your Honor.
All right, so you're still at 45 minutes?
I think it'll be shorter than that myself, Your Honor.
I think we can probably beat that estimate, probably around 30 minutes.
Okay. All right, well, we will do that, and then we'll start on Matula. And I believe all that will leave is Peeler.
Your Honor.
Yes.
I apologize for interrupting, but this is Lawrence Wells with the Attorney General's office. And
okay. Yes, sir.
And I just wanted to say, I'm sorry. I just wanted to say when you get to the Green case that I finally got him on the line. They had a security incident, but I'm going to get him on the line, but I'm going to ask for a continuance because I found out he filed an amended petition yesterday, and I have no idea what it says or whether he's cured his problems or what. And he got no notice of the hearing for some reason.
Okay, and I had called earlier and didn't hear anything, so I had it as no show. But
I'm sorry. Evidently the mute was on, and I didn't realize.
All right. Well, I have you labeled now with your name. How long will it take you to get him online, or it just depends?
Well, he's online. Just a moment. I can get him.
Judge Krista Castañeda on the BOKF matter. I apologize for interrupting. I have to depart at noon, and I didn't know if you were going to be able to reach us. I could confer with other counsel and see if we can get a reset.
All right. And how long did y'all announce for?
I personally say it's 20. They said it was 45.
Okay. All right. No, we'll take that up next. I'm sorry, Ms. Carter.
Okay. Thank
I
you.
apologize, Judge. I think Mr. Green's on the line. Is that true, Mr. Green?
Yes, sir.
Okay.
All right. So recalling the docket 20-08-149, James Thomas Green versus Texas Department of Criminal Justice et al. And these are defense motions, but I understand from the attorney, Assistant AG, Mr. Wells, that he believes there's a problem with service. And so are you announcing ready, Mr. Green, or not ready?
I would announce not ready. I had just been notified of just received a copy of one of the motions yesterday, and basically was told there was a hearing today, but I wasn't real sure what the deal was. I
I didn't have time to file any kind of response or anything. I'd have no way to preserve any error if I think there was error. I have nothing on in a response for that.
Okay, so how
And he filed,
long
he
do we
filed a
need?
new pleading off.
All right, so how far down the road do we need to set this?
Oh, around the first of the month is fine with me, somewhere in there. This is Wells again.
Let's see, this is the 21st.
Okay, how about the 11th?
Okay,
That
that
is
sounds
supposed to
good.
be- well, that's a
That
LaSalle
would work.
update.
That will work, Your Honor.
Oh, yeah, I agree with that. That sounds good. That'll give
Judge,
me
that
time to
date is
file
pretty full already.
Is it?
Yes, you have the Peeler case. It's got 3 hours and I've already kind of closed it out because it's a full docket.
All right, what's some other date that this could be heard? It didn't have to be on my docket.
The 10th or the 8th would work.
All right, and
16th, 17th, 18th.
Okay, and can this, all right, be set up where Mr. Green can call in directly, or?
Oh, yes, Your Honor. I can set it up.
Okay.
Okay, all right, well, I'll set it for 2:10 and
On what date?
the 10th of February,
Okay.
Okay.
What time?
9 o'clock.
Thank you.
All right.
All right, y'all are excused.
Mr. Wells, can I speak with you for a moment?
Yeah, you can, I'll mute it, but y'all can speak offline. Go ahead.
Okay, all right, fine.
All right, in the BOKF case, Mr. Lipper, I believe, is he on?
I'm here, Your Honor.
I believe you had sent me a link, but I had to have an account at your firm to open that up.
Oh, gosh. I didn't realize that. I'm going to need to get this to you because there's a lot of paper with it, Your Honor. We can certainly argue it. You can read it post-hearing if that's best. I know Ms. Castaneda has a flight she wants. What procedurally is the best way, Your Honor?
Just post it in chat is fine.
Okay.
If it's not too big, or if it's
Yeah, the problem was it's 3 pleadings. It's probably about 200 pages altogether.
If you post them one at a time, I get some pretty big things. We'll see.
Okay.
100
Now,
pages, I'd say it probably choked down.
okay, let me, so I go into chat, Your Honor?
Yes, sir.
And,
there should be a file. If you click on my name or everyone, there ought to be a little, looks like a piece of paper with a corner turned down to the right that says file.
I've
But
got it.
sometimes there's not.
Let me, I got to move this stuff to my desktop to get to it. Just one moment, Your Honor.
Judge Krista Castaneda for plaintiff BOKF. As I mentioned before, Eric Lipper and his law firm have been disqualified as counsel, and I'd need to be heard on the motion to strike this.
Hold on. Your Honor, I don't want to, while I'm trying to get files to the court, I don't want to start arguing the materiality of
All right, Mrs. Castaneda, do you have your motion?
Yes.
And I guess
I shared it in the chat, Your Honor.
I haven't seen
okay.
it.
All right, well, if that happened before I rebooted my computer, I did not get it.
Your Honor, if you open the chat, you should see what I had posted, I think. I can try it again.
All right, if you'll recall, I rebooted my computer because everything I started downloading was corrupted. And what happens, that's some kind of Zoom error or my computer error. It doesn't matter who it comes from. Every document I try and download is corrupted once that starts. So I rebooted, and when you reboot, the previous chat is.
So I've just chatted to everyone a PDF of the motion to quash and motion for protection.
Right. Your Honor, procedurally what we have set today is our motion to quash. If there is still some effort to try and disqualify me as counsel, that needs to be set for a hearing, and that's not before the court's docket today.
Actually,
so if Your Honor,
Mr. Lipper finish.
Right. Your Honor, in order for me to go upload these other items to the chat, I need to be able to do that, but I don't feel like it's appropriate for council to be arguing material issues while I'm trying to take care of these procedural matters. We have a few minutes for me to make sure I get all the documents to the court.
Your Honor,
Yes.
I just sent you plaintiff's motion to quash. I don't have
All right,
all
yes.
the documents to it.
And I'll start looking at these.
And I also sent I sent you defendant's motion to quash and motion for protection, the first link. So I've sent you Mr. Lipper's main pleading. I didn't include all the attachments. And I've sent you our motion to strike that motion to quash and the response subject to that motion to strike.
And we have a reply to that. And I think you should have the exhibits, Shara. If we could have a recess for a few moments, I'll make sure the court has the as filed documents.
Just wanted to check with you. So you have this one, and then you have another one that's 30 minutes, and then Matula, right? Okay, so is it okay if I go to lunch from 12 to 1? Okay.
Sure.
Unless you need me, but you should have the file.
Your Honor, I think I've put them up there now.
Okay, let me finish reading the motion here from the plaintiff.
Your Honor, I'm sorry to interrupt the court and my colleagues, but I wanted to let you know on the Matula case, Abel has a hearing from 1 to 1:30. And I just wanted to let you know so you can manage your docket with that. I'm happy to start after his hearing.
That is correct, Your Honor. I have something at 1 o'clock. It's a permanency hearing with CPS Atascosa County. They've given us just a small slot. So we'll be ready to go after that. And if we start prior to that, I would hate to interrupt the court.
I've got a 3-hour hearing with the Peeler case.
Or perhaps we can stop. We can start and maybe stop in the middle. I'm not sure.
Well, 3 hours, we finished early Tuesday, but typically if there's an announcement of 3 hours, it's closer to 4. So, okay. So I'll let y'all, would either of you be available tomorrow sometime?
Tomorrow morning.
It would have to be after lunch. I've got a physical therapy and a meeting with the JPs.
I can adjust my schedule.
Yes, sir. I can do that.
All right, say 1:30?
1:30 tomorrow afternoon is fine.
Okay, all right, then I'll see y'all at 1:30. I'll ask Ms. Riley to set that up and send you the Zoom links.
Thank you very much, Your Honor.
Thank you,
Thank you,
Abel.
Ms. Whitley.
Bye-bye.
Okay. All right, so we have a motion to quash. Let me download all of that.
Was that all for LaSalle County, Judge?
No, there's still, no, that was a Wilson County case that just left, so there's still. this
Okay,
one.
okay.
All right, let me look at the response to the motion to strike, and then we'll get started. All right, I think as a preliminary matter, we should take up the motion to strike briefly first. Go ahead, Ms. Castaneda.
Yes, thank you, Your Honor. Eric Lipper and the law firm of Hirsch and Westheimer have been disqualified as acting as advisors or counsel to the Equinor defendants or participating in any discovery relating to this subject matter. The 101st District Court, upon special appearance by Eric Lipper and his firm in a motion hearing, issued an order of disqualification, which I'm happy to display on the screen if the court would like.
I've looked at your exhibits. Go ahead.
Okay, and so the order is clear, and what we have before us today here in this matter is a discovery motion, and Mr. Lipper's continued attempts to participate in discovery and to counsel the Equinor defendants on what is an inherently related subject matter. That the Dallas Court of Appeals order is straightforward. It has not been appealed. The defendants of Lipper and Hirsch and Westheimer were present, and the court took jurisdiction over the matter. There's been no attempts to set it aside, and yet we have here them attempting to participate in discovery and advise Equinor in contempt of that order. I'd suggest that this court should respect the order of a court of district court order in Dallas County that assumed jurisdiction over Mr. Lipper, and which was not challenged, and they are not allowed to participate in discovery relating to this matter. And let me just say, Your Honor, we don't, if necessary, I will reset the whole motion to disqualify, but BOK retained Hirsch and Westheimer for a period of about 10 years. They were in possession of its confidential information, which not only did they tape all of the phone calls with BOKF, but they attempted to introduce them into evidence in the hearing. So under Texas Disciplinary Rule 1.09, because they are in possession of BOK's confidential information, Judge Williams correctly disqualified them from participation in a matter adverse to BOK. It doesn't have anything to do with where this case will ultimately be tried. It has to do with that court's ability to police the ethical rules of officers of the court. Hirsch and Westheimer had its hearing there. They lost. They didn't take it up on writ of mandamus or on any other matter. The order stands, and I ask that this court respect it. And as a result, strike the motion to quash the deposition notices or instruct that it be refiled under the name of Travis Barton alone. If this proceeds any further, we will seek also the disqualification of Equinor's other counsel on the grounds that the taint of the disqualification and the reasons that they were disqualified has spread to additional counsel. We don't want to take it any further than that, that I must be understood to know that we are not waiving this matter and that it is a serious matter, and we ask that the court respect that order and agree that Mr. Lipper and Hirsch and Westheimer are disqualified from representation of Equinor, and that they cannot proceed in this hearing today to argue this motion.
Your Honor, may I respond?
Yes.
So first off, there was a serious procedural issue with the order that you're looking at of disqualification, which we've raised in our response. Was I was never counsel of record ever in Dallas, Texas. We didn't answer the case. I never appeared as counsel. They filed a motion to disqualify us as counsel in LaSalle County, which we asked to be set for a hearing. They then went to Dallas and had it set in Dallas while we were awaiting a hearing in LaSalle County. The first motion up in front of the 101st was a motion to abate the case under the concept of dominant jurisdiction. That order was signed on May 18th, 2020. We objected to that ruling because we think LaSalle County retained dominant jurisdiction because it was the first filed case, the only case in which Equinor had been sued. We filed a petition for writ of mandamus to the Fifth Court of Appeals in Dallas on June 4th of 2020. We gave notice to the trial court of that filing on June 4th of 2020. And on June 6th, 2020, an order of disqualification of us as counsel was signed. If you read the order of disqualification, it's interesting in how it's interlineated by the court, which is, of course, it makes sense. It says they're disqualified in this case. Now, we disagree that there's any factual or legal basis for the disqualification. But more importantly, that order of disqualification was signed on June 6th. When the Dallas Court of Appeals issued their petition, their order granting the petition for writ of mandamus, the Dallas court entered an order vacating its decision to deny the abatement, which was at the May 18th order. The order goes back, it relates back to May 18th, which says it replaces the prior order, which means that by the time the court signed the disqualification order, it did not have jurisdiction over Equinor or anybody because that order was vacated. But more importantly, even at best, the order of disqualification was limited to this case and was right to the 101st. The case before Your Honor never left. It was not non-suited, it was not abated, it never left this court. Now, we have invited and requested that Your Honor have a full evidentiary hearing on the issues of disqualification, because I can assure you, Your Honor, if there was anything, and I've appeared before this court before, if there was anything that I thought was remotely the basis for disqualification, I would resign as counsel. But there is zero here. This alleged 10-year relationship between BOKF was handling consumer check cases 6 consumer check cases. Nothing in our relationship had anything to do with the issues at hand before your honor. And lastly, on the issue of the motion to strike, it is untenable as a matter of law, because if you look at our motion for protection, it is in fact filed by Hirsch and Westheimer and McGinnis Lockridge. McGinnis Lockridge is, nobody has filed a motion to disqualify them as counsel. So there is no factual basis for the strike. There is no legal basis for the strike. And what I would ask your honor to do is to deny the motion to strike, and let's take up the substance of the issue of protection.
All right, anything else? Ms. Castaneda?
Yes, Your Honor. Equinor continually confuses the issue of an abatement with subject matter jurisdiction. Equinor is still present in the Dallas County case. It has only had an abatement granted, which, as the honor knows, is cessation of the proceedings in favor of what the Dallas Court of Appeals said was dominant jurisdiction here in LaSalle. We have taken that up to the Texas Supreme Court. It is still pending. It has been pending for 3 months. We believe that Dallas County is the court of dominant jurisdiction, but regardless, that is a venue issue. It is quite clear that it is a venue issue and not a jurisdiction issue. So Dallas County had jurisdiction to enter the order. It entered the order, and it is quite clear that Equinor cannot act as discovery counsel or advisors in either that case or any discovery proceedings related to it. This is a discovery proceeding related to the Dallas County case. All discovery in both cases has been combined, always has been combined. We have taken 7 depositions. We produced 200,000 documents in the combined cases. The experts have been tendered in both cases. We are ready to depose Equinor's experts in both cases, and Hirsch and Westheimer are clearly precluded from participating in that. So we again ask that the court recognize and respect the order of the 101st District Court and order that Eric Lipper and Hirsch and Westheimer cannot proceed to represent Equinor as counsel, advisors, or discovery counsel in these matters.
Okay. All right. I will deny the motion to strike. I certainly am not disrespecting another judge's order. If Mr. Lipper and his firm are in violation of a valid order restricting their activities in this litigation, then that can be presented to the 101st in Dallas County, and they'll have to answer there. All right. So
thank you, Your Honor.
who is going to argue, Mr. Lipper, Mr. Barton? Who is going to argue the motion to quash?
I'm going to argue it, Your Honor.
All right, go ahead, sir.
Your Honor, there are really 3 essential reasons why I think the motion to quash should be granted. One of them is the unique procedural place where we sit right now, which actually there's almost an agreement between Equinor and BOKF on this limited point. We believe the Dallas court got it wrong on the abatement. And we believed that the Dallas court did not have jurisdiction because LaSalle County retained dominant jurisdiction. We were successful on that. The 5th Court of Appeals issued a very well-reasoned, multi-page opinion on that and ruled that the case should have been abated. Since that time, BOKF has taken it to the Texas Supreme Court. Now, they've taken it to the Supreme Court on their own petition for writ of mandamus. The Supreme Court has not done anything with it. They haven't granted a stay. They haven't asked for a briefing on the merits. They haven't said anything for hearing, but they also, Your Honor, haven't tossed it out. And so as we sit here procedurally before this court, there is a possibility, I think it's remote, but there is a possibility that we're back in Dallas. There's also a large possibility we're here in LaSalle County. But Ms. Castaneda, in her response to our motion to quash, asked that this case be abated until the Supreme Court rules. And I'll be honest with you, Your Honor, we think that's a smart move. We don't need a formal abatement, but we certainly agree that we don't want to incur attorney's fees or take depositions in any case if there is any question as to the court's jurisdiction. We think there is none, but BOKF has raised it. So that's our first point. Our second point is because of the status of where we are here in LaSalle County, we don't have a docket control order or an order requiring the designation of expert witnesses from this court. The reasons are understandable because as we were matriculating through the court, I got involved in this case in October of 19. I got involved in October of 19. They filed a lawsuit adding us in Dallas December 31st of 19. We didn't answer it till February of 20, and we immediately objected to the jurisdiction, but we did nothing in LaSalle. And then, as you remember, the virus hit and LaSalle County has abated all scheduling issues. So procedurally, we think before we have expert witnesses, there should be a requirement that we in fact designate expert witnesses. And we have still not designated in LaSalle County our expert witnesses. Now, we had produced some expert witnesses in Dallas, but we were not done in Dallas either because we showed up late to the party in Dallas. So we think that this court should enter a clear order that says your designation deadlines are on date X. Presumably they'll relate to some time when we think we'll be getting to a trial. And we think that's another basis to quash. The last basis to quash is perhaps the most frustrating for me as a trial lawyer, which is these depositions are noticed in two lawsuits. The Repsol case that's pending in Dallas, which was abated as to us because we're in LaSalle County and in LaSalle County. Now, on this Zoom call somewhere, at least at one point, was one of the lawyers representing Repsol in Dallas. The rules don't permit joint notices of depositions in two separate cases in two separate counties. In fact, looking at, I think it's Rule 199, Your Honor, which discusses the decorum and rules and depositions, it says only parties can ask questions in depositions. And the deposition rule, if you read it, ties back to, and it uses the language of what you could do in the trial of the case. Now, nobody from Repsol is going to have permission, I would assume, from Your Honor to attend a jury trial to which they're not a party and examine and cross-examine our expert witnesses. That would be very unusual. I've never seen or heard of that happening. So we don't really see a reason why Repsol should be attending our depositions. Now, I wouldn't mind if the reason Repsol was there was what the rules permitted, which was counsel can always give notice that they are bringing an additional person to the deposition, because they can be like an expert that's going to assist them in formulating their questions. It can be some other advisor, client, whatever, but that's not Repsol standing. Their notice to come to the deposition is counsel. The last thing is, and this is related to something that Your Honor has signed, was you executed at the party's request a protective order, protecting the confidentiality of documents that were to be produced in this case. Now, the protective order had in paragraph 6 some language that said one of the essential purposes of this is to protect the materials, but also to allow discovery in one case. Because remember, there were two cases. There was a Repsol case in LaSalle and an Equinor case in LaSalle. And the parties agreed that the discovery from one case may be used in the other case, but nothing said that it was joint discovery. It was the obverse, which was we're all agreeing that things that we discover in our case, the other party can use subject to rules of admissibility and things of that nature. But one of the things that's core to that order, and you'll see when you look at the protective order, was it was in two cases in LaSalle County, signed by Your Honor, And there was no contemplation when that protective order was signed that there would be an agreed transfer of venue by Repsol to Dallas County. The parties retained the right to amend or modify the order. And certainly when we get back before Your Honor procedurally is we have taken every effort to segregate ourselves from Repsol legally. The plaintiff had the opportunity when they filed this lawsuit to have sued both Equinor and Repsol in a single case. The Dallas Court of Appeals pointed that out. But plaintiffs make choices when they file lawsuits. And this plaintiff made the choice to divide and attempt to conquer. And we want to retain that division. And we don't want anything that confuses the division. And Your Honor, I'm very concerned that the efforts that are being undertaken by BOKF are entirely to try and drag us to Dallas. Now, I'm not accusing the Dallas court of impropriety or anything like that. Please don't assume that. But what I'm saying is I don't feel like we're getting fair hearings. We would get a fair hearing in Dallas. And I feel like when we got sued in LaSalle County, that we had the opportunity, if we didn't think that we could get a fair trial, to make that objection. We also had the opportunity, if we thought venue didn't lie in LaSalle County, to make that objection. But we never, when we got sued in LaSalle County, think, let's go see what a Dallas judge thinks about my dispute in LaSalle County. That never was in the context. We want to remain in LaSalle County. We want our issue determined in LaSalle County. And I believe that the first point is maybe the most compelling, which is we should all stand down in this lawsuit until the Texas Supreme Court gives us guidance. And I would assume that's going to happen soon, Your Honor. That concludes my argument.
All right, Mr. Barton.
No, I think Mr. Lipper nailed it. The only thing I would add is on his point about the scheduling order. Certainly it's our position that the court should enter a new scheduling order, and that new scheduling order will contain expert designation deadlines, and the parties then will engage in conventional discovery. Both parties will designate their experts, and then both parties will take depositions of the plaintiffs first and us second. We don't think there's any circumstances that warrant completely throwing that process in the trash and trying to hurry back and do a joint discovery, joint expert depositions in Dallas County when we don't even have a scheduling order in LaSalle County.
Ms. Castaneda?
Yes, Your Honor. The question before the court is whether the plaintiff is entitled to proceed on a deposition that has been noticed in this case. That we have noticed experts that have been designated by Equinor relating to this case in this case. And all of this stuff about Dallas County when it comes to our right to take this deposition is surplusage. It's specious, and furthermore, it belies the 2 years of combined discovery that the parties have engaged in. Equinor has taken depositions in both cases. Equinor has tendered witnesses in both cases. Every deposition that has been taken relating to the STS lease, whether it's in the claims against Equinor or the claims against Repsol, has been in combined discovery. There is an order that is applicable in both courts that was signed by this court when both cases were originally pending in LaSalle County that says we get to engage in combined discovery because it's the same lease, it's the same operations, it's the same basic accounting data. And as we learned when we began to take this discovery, and the reason that we joined Equinor into the Repsol case, because there was such an interweaving between the two companies in the way that they relied on each other's data to settle royalty, that it was clear that it was a judicially efficient way to resolve the dispute to try the two of them together. So we added them in. All right, we've got a dispute over where the venue for trial will be against Equinor, but what we don't have is any request to undo the order that was signed by this court and is now pending in both this court and in Dallas County, saying that we get to conduct discovery in both cases and that we do not have to subpoena separately. And so we have noticed Equinor's designated experts for use in this case, and we are entitled to take that discovery. We offered Equinor the right to take our depositions of our experts first, and they declined. So we're entitled to take their experts. It's very clear that our experts were tendered in both cases to opine as to the claims against both Equinor and Repsol because the operations were the same, the lost volumes were the same, a lot of the sales and marketing arrangements were the same. And so we tendered experts in both cases, and Equinor tendered expert designations in response to our experts. We want to take their depositions. It doesn't matter that there's no discovery deadline. It doesn't matter that it's going to still be sometime before we get to trial. This is a 9-year-old dispute now, and it has been pending for 3 years. We're entitled to take the discovery, Your Honor. They've shown no grounds for protection. And so we request that we be able to proceed with Equinor's expert discovery.
May I respond briefly, Your Honor?
Yes, sir.
Let me address a couple of the points that counsel's raised. First is that we have had 2 years of combined discovery. There is some accuracy in that statement, Your Honor, but where the accuracy leaves is there has been no combined discovery since they sued us in Dallas. Once the lawsuit was filed in Dallas, there has not been a deposition taken since we got sued in Dallas. There has not been anything conducted in terms of a deposition. And in fact, there's a Rule 11 agreement that we have tendered to the court, which expressly states in it that we reserve all rights and remedies that we have to suggest that LaSalle County is the sole place for proper jurisdiction over Equinor. The reason that there was previously combined discovery is what Mr. Castaneda raised, which was we did see some judicial efficiency at that time, but we were never seeing efficiency in the sense that we would be subjected to a lawsuit in Dallas. Now that we've been given that taste, we have no interest in participating in Dallas. The next thing is that she makes reference to that there is an order in both courts requiring combined discovery. I would ask Your Honor to read the agreed confidentiality and protective order that has been signed by Your Honor. Paragraph 6.
And that was the only thing I could find that had both clause numbers on it.
Yeah, that's it. It's paragraph 6 of that protective order. But if you notice, and I don't want to fine point this to death, but aside from the fact that the language does not require joint discovery, what the language is in a paragraph entitled Use of Discovery in the Two Captioned Cases. The parties' agreement was the two captioned cases were both in LaSalle County. We had no role in the Repsol BOKF decision to transfer their case by agreement to Dallas County, and we didn't think that their basis to transfer it was right. But once they decided to do it, that ended this language entirely, even if there was a requirement of joint discovery, which it doesn't say. The next thing that I would like to raise in response is the issue of the practicality of what we've got before the court, which is Ms. Castaneda talks about our experts. There are no experts designated in this case. There certainly may be when we get procedurally to the right moment. But right now we got drugged to Dallas. We didn't answer the case until late February. There was a long-standing order up in Dallas that said, give some experts. We put it together in a hurry, Judge, because they accelerated it under the theory we were going to go to trial in the summer, but for the fact of the virus. Now that we're back here, by the grace of the Dallas Court of Appeals, we want a legal reset. We want to go back to what we would have had if we hadn't been on a one-year field trip to Dallas. Now, if the Supreme Court tells us, sorry, the Fifth Court of Appeals got it wrong, you guys go back to Dallas, we'll take our lumps at that time. But we're here before your honor. There's no joint discovery order. We think there is a great basis for protection, and at a minimum, the protection should be stand down until the Texas Supreme Court rules.
Your Honor, I have to correct some blatant misrepresentations of fact that Mr. Lipper just made to the court. We've taken at least 3 depositions. Equinor tendered a corporate representative in both cases after they were in Dallas County. They took our corporate representative in Dallas County. They took another BOKF fact witness in Dallas County. Equinor, all discovery has been combined in both cases. All of the negotiations about the expert deadlines was for both cases, and Mr. Barton knows it because I negotiated it with him. The Rule 11
by both cases,
agreement,
you mean you're considering the Repsol case as one case that was transferred to Dallas County?
yes, sir.
All right, go ahead.
I'm sorry, I think I understand your question. There's a
Okay, and just to be clear, the Repsol case was transferred to Dallas County.
The Repsol case was transferred to Dallas County. That's correct. And after it was transferred, and after Equinor, it was added to that case, and even before the abatement issue was determined, Equinor participated in discovery in both cases. Okay, and after they lost the abatement motion, they continued to participate in discovery. They took depositions in that case. All discovery has proceeded in both cases. Our entire history of negotiations about when expert designations would proceed is that we were designating experts that for opinions that could be used in both cases. And Mr. Barton agreed to certain Rule 11 deadlines for those expert designations, and those matters are within the record. Your Honor, I mean, it's a rewriting of the history of this case for Mr. Lipper to come in now and say, oh, we never had any deadlines ever. That's just not true. We agreed, Mr. Barton and I agreed that as of the COVID deadline of May 31st, whenever those orders were, that this court had removed all of the scheduling order deadlines, but nowhere did we agree that we were no longer proceeding with discovery or that we would no longer agree to conduct joint discovery, which since those have been memorialized in a court order in 2 separate courts now, would require a revision to that court order. They haven't asked for it. I mean, we're just simply seeking to depose. They've tendered their experts. We're seeking to depose those experts. They've got material opinions about what happened here. It's relevant. There's been no showing that it's burdensome. I mean, it's not a judicial nullity. They did it, and now we want to ask their experts questions about it. It's that simple.
Your Honor, may I address a couple of those points? I think I can clear a couple of those things up briefly. Unfortunately, Ms. Castaneda is leaving out some key details that are not accurate. First, we did disclose experts when we were in the Dallas court. We did disclose experts in the Dallas case. We expressly did not disclose any experts in the LaSalle County case. She keeps confusing that and acting like those designations were in both cases. They were not. Next, in the Rule 11 agreements, we never agreed to joint discovery. We specifically insisted on reserving all of our rights on this issue. This issue's been a big issue. We've been fighting about for a year and a half. We reserved our rights on this issue in that Rule 11 agreement. There is no Rule 11 agreement with Equinor saying we agree to joint discovery in Dallas. This whole concept of joint discovery is completely wrong because the idea, if you look at paragraph 6, it's real clear. It's separate discovery, which then can be used in the other case. This whole theory only arose once STS took Repsol to Dallas and then later decided to join Equinor in Dallas. There is no agreement for joint discovery in Dallas. In the depositions, in the expert reports we presented, we're only in the Dallas case and we're not joint discovery. We have not submitted expert reports in LaSalle County. Thank you.
Your Honor, let me
briefly, I know Ms. Castaneda has to leave.
I'll be very quick.
I mean, I presented all the information to the court. The deposition errata sheets and certifications are in both cases. The Rule 11 was for experts in both cases. The opinions that were tendered are in response to our experts that were designated in both cases, and the opinions apply to both cases. It's a complete rewriting of history here to say that Equinor is now no longer agreeing to discovery that it memorialized in the court order that they've never moved to amend. So, Your Honor, we're entitled to take the deposition. Please let us go forward with discovery.
Your Honor, may
And what about wasn't there a Rule 11 agreement, it looks like, that says that you agree that all the scheduling deadlines in LaSalle County are suspended by the court orders related to COVID?
But there's a date in there, Your Honor, as of.
Correct, Your Honor. And that supports our position as the basis of our position that we're not making designations in LaSalle County. Those deadlines are suspended. We're going to have new expert designation deadlines, and we'll decide.
Okay, and that's enough from everyone. I will not grant the motion to quash. I will, on my own authority, abate discovery for a period of approximately 30 days, but that will be until April the 20th. I'm going to set this for April 20th, 90 days, I mean, and with the understanding that if the Texas Supreme Court comes up with something one way or another, prior to that, just on the regular amount of notice, people can set this for hearing, and I'm going to set it for a entry of a docket control order, and hopefully we'll have the ability to enter a docket control order then. And I guess I would just conclude that, yes, if the deadlines were suspended, if there's no docket control order requiring parties to do something, if they want to do that by agreement, that's great. But if they're objecting, then we'll get a docket control order entered. I also ask you might just contact the court or the coordinator's office ahead of that time to see what we're looking at. Hopefully we'll be able to do jury trials. The only county out of the 5 that we've had it set up to where we could have jury trials with social distancing is Atascosa County, and the one we had scheduled fell through. LaSalle County probably has enough room that we could do that. Some of the other counties do not. Certainly couldn't be done at the courthouse. But there's going to be folks looking at possible prison sentences who can't make bond, who are stacked up. So I said last year that when we got to doing jury cases again, that the backlog was going to look like a pig going through a python. And now I think it's going to look like a water buffalo going through a python. So, I mean, that's not good that we're telling folks that, you know, if we have to start doing COVID social distancing, I don't know how much that's going to increase the time it takes to do a jury trial, but it's going to be a good bit. It's going to be even harder for us to get caught up. And obviously a lot of these things will settle once people's the fire and they have to actually show up and try something, but nothing's going to happen anytime soon anyway. And if you're up in Dallas, then you're up in Dallas. If you're down here, either on April the 20th or before, if we get a word from the Texas Supreme Court, we'll get a docket control order entered and make all of these things happen expeditiously.
Your Honor, we are proceeding in Dallas.
Okay.
That case is not abated, right? We're going forward in Dallas as to Repsol. So we will subpoena these experts in Dallas. If that's what the court's order is.
And that's fine. And then y'all can, if Mr. Lipper wants to, or Mr. Barton wants to take that up with the judge in the 101st, that's great.
Okay, thank you, Your Honor. And if we return here, you know, whatever happens in the Supreme Court happens in the Supreme Court. But if we return here and we are to try the case here, then we will need to be heard on our motion to disqualify Hirsch and Westheimer, which has been pending.
Certainly. Okay. All right.
Thanks, Your Honor.
Mr. Barton, will one of y'all?
I'll prepare an order.
Prepare an order? Okay.
I will prepare an order and circulate it to council.
Thank you. Thank you for hearing us before
Yes,
noon.
good luck with your, well, it's a little after. Hope you get your plane.
I appreciate it. Thank you. Bye-bye.
Thank you. Bye.
Thanks, everyone. Bye.
Lipper, there's another case on the docket where one of the attorneys said Tuesday that in 30 years, he'd never seen one case with so many motions. And I told him, you may be passing the record that I'd seen. So.
Yeah, well, look at my hair. So.
Okay, so y'all are, you were released. Mr. Barton looks like he's already taken off.
Yeah, thank you, Your Honor. It's good talking to you.
You're welcome. Okay, Karnes County. Opiella? All
Yes,
right.
Your Honor.
Did
Yes, Your Honor.
anyone send me the motions I need to look at?
I will drop them in the chat box right now, and I can do both the motion and the response.
Thank you.
All right.
You download these.
Judge, just to interrupt real quick, I believe a Ronald Rickaway came online. He's connecting to audio. I'm not sure if he can hear, but I believe that case with Wilson County was dropped and reset on request.
Yes.
At the request of Teresa Nettles. So I think Mr. Rickaway, you don't need to be in the hearing at this time.
Yes, sir. You're welcome to hang out, but
Hello?
yes, we can hear you.
I'm sorry, this is my first Zoom meeting. So I'm not supposed to be here now?
Well, sir, I mean, you're welcome to stay, but your case was reset. Now, you were not here. The attorneys were. I think I'm not sure if both attorneys were here or not, but one of them, Ms. Nettles, whoever's attorney she is, appeared and announced that it was going to be reset.
Okay, all right. Okay, well, thank you for your time. I'm sorry for the interruption. You guys have a wonderful day. Thank you. Bye-bye.
All right, I've read the motion. Let me look at the response. All right. Go ahead, Ms. Covert. This is Yella versus someone or another.
Enervest Operating
Enervest.
LLC et al. Thank you, Your Honor. Stephanie Cover on behalf of defendants moving party in this motion. So what you have before you is our motion to compel production. It's very targeted. It's just one document. And because this is so straightforward, I'm going to delve right into the issue with little background. Plaintiff is withholding a discoverable settlement agreement. Defendants requested the agreement in both request for disclosure and request for production. Plaintiff's sole basis for withholding has been that the agreement contains a confidentiality provision. Texas law is clear that that's not a valid basis for withholding. Confidentiality does not mean a document isn't discoverable. And private parties can't contract to restrict discovery. But on top of that, in this case, we already have an agreed protective order that's been entered. So confidentiality concerns can be addressed under that order. Plaintiff doesn't dispute these points in his response, and it's unclear the extent to which the confidentiality assertion and objection is still in play. I'll say the other party to the settlement agreement that we're seeking is Blackbrush Oil and Gas. They know of this dispute. They have decided to not attend the hearing, and they've requested that if production is compelled, that it be made pursuant to the protective order. Because there's no basis for the confidentiality objection, plaintiff changed tact and now asserts in his response that the settlement agreement isn't relevant. But plaintiff waived his relevance objection because he didn't timely assert it. He didn't assert it in his responses to our request for disclosure. He also didn't assert it in his specific response to our RFP that specifically requested the settlement agreement at issue. And why does that matter? Rule 193.2 says that any objection not asserted in 30 days, the deadline for the response, is waived. So that right there should be able to end this inquiry, and the settlement agreement should be produced on those grounds. Now, I don't doubt that plaintiff's counsel will assert some kind of good cause. I don't think he established that in his response, but I'm sure that he's going to try to establish it here. So I'm going to go ahead and discuss now how, even if plaintiff's objection were timely and he hadn't waived his relevance objection, relevance is absolutely present here. Rule of Evidence 401, that's what sets forth our test for relevance. Evidence is relevant if it has any tendency to make a fact of consequence more or less probable than it would be without the evidence. So any tendency to make a fact more or less probable. And when we apply that standard, we see the settlement agreement is relevant to our case, and here's why. This case concerns a piece of property owned by plaintiff. It's a 637 acre tract in Karnes County. And plaintiff's claim in this case is that on July 4th, 2018, a lightning strike hit oil tank batteries being operated on the property by defendants, and that resulted in a release of fluid onto the property. Now, plaintiff alleges permanent damages, and he seeks loss of market value. And it's important to note that plaintiff seeks loss of market value for the entire property, the whole 637 acres, not a corner of the property, the whole property. And so far, his expert asserts that there was a 35% loss in total value. So a central issue in our case is the value of the property. What was the value of the whole property before the lightning strike, and what was the value of it after? And that's where the settlement agreement, the document we're seeking here, comes into play. Because on the very same property, there was actually a prior release of fluids back in 2013, and that didn't involve defendants. What involved was a pipeline that had ruptured, and it released contamination under the property and into the groundwater supply. And plaintiff, this same plaintiff here, brought a lawsuit related to the pipeline contamination. And he brought basically the same claims that he's bringing now related to this release. And he claimed a loss in market value, not of just a corner of the property, but the entire 637 acres. And just like here, he claimed that there was a 35% total loss. The pipeline contamination is still there. It continues to affect the property, and remediation of that contamination is ongoing. Now, that case settled, and that settlement was memorialized in the settlement agreement. And so what we need to look at are the obligations and rights under the settlement agreement, because they directly affect the valuation of the property that we need to perform in this case. And when you do a valuation, you put yourself in the shoes of the potential buyer. And there's a host of questions that the potential buyer would be asking about the settlement agreement. Now, as you just saw, we laid these out in detail in our brief, and I'm not going to repeat all of them now. But let me present it to you this way. If your honor were buying this property, wouldn't you want to know whether the settlement agreement granted any easements related to the ongoing remediation? Or wouldn't you want to know whether you, as the new property owner, would have any rights to enforce the settlement agreement, enforce cleanup of the property after you purchase it? Wouldn't you want to know whether the settlement agreement requires or could potentially require the filing of a deed restriction, which could significantly affect the value of the property after you purchase it? And wouldn't you want to, of course, know how much the prior owner was paid for a reduction in property value due to the spill? As the potential buyer, of course you'd want to know. That's why this is relevant to the valuation. And that's exactly why we need to know what's in the settlement agreement to defend against plaintiff's current valuation of the property. Another way to put it is, imagine if you were going to buy the property and your honor asked plaintiff about some of these issues. Hey, I'd like to know whether the settlement agreement requires a deed restriction or has easements, or what the reduction in value was due to this contamination. And plaintiff told you, that's not relevant to this sale. You actually don't need to know that. That would be absurd, because we know that it's precisely because it's relevant to your valuation that he doesn't want you to know that information. Now, plaintiff's response doesn't address these points of relevance I've just discussed. And there are other reasons why the agreement is relevant that also go unaddressed in plaintiff's response, but that we set forth in our motion. The agreement's relevant because it can be used to demonstrate the bias or prejudice of witnesses. Plaintiff has a valuation expert in this case. We need to know whether plaintiff's valuation expert considered the provisions of the settlement agreement or did so appropriately, and whether his opinions are inconsistent with them. Plaintiff himself is going to opine on the value of the property. He's already litigated and settled one case related to a release on the very same property. At minimum, the settlement agreement makes it more or less probable that his opinion may be biased. And that's all that Rule 401 requires for relevant evidence, more or less probable. In addition, the settlement agreement goes toward damages in another way related to the one satisfaction rule. A plaintiff shouldn't be compensated for the same injury twice. In the prior case, plaintiff asserted a 35% across the board reduction in total property value related to the settled case. Plaintiff now asserts, in this case, a 35% across the board reduction to total property value. Plaintiff can't recover twice for the same injury, and the amount of actual compensation plaintiff received in the settlement is relevant to damages in that rule. Now, I could go on and explain, as we do in our brief, other ways in which the settlement agreement affects material issues in our case, but I'm only discussing the merits of relevance as a field stop. The bottom line is that plaintiff waived his relevance objection by not timely asserting it. And I feel comfortable that Your Honor understands the point I'm making regarding relevance. So let me finish by saying that respectfully, Your Honor, I believe plaintiff's counsel needs to explain three things to you. First, why he's entitled to withhold a document in discovery on a claim of confidentiality when Texas law makes crystal clear that can't be the basis of withholding. Second, he needs to explain why his relevance objection should even be considered by the court because he waived it by not timely asserting it. And third, he needs to explain why not one of the items I discussed with you or that are contained in our motion, why not one of them has any bearing on the valuation of the property or this case. Or to put it another way, plaintiff's counsel needs to explain why, if Your Honor was thinking of buying this property, you wouldn't want to know any information in the settlement agreement and you wouldn't feel any need to assess how it impacts the value of the property before you purchased it. Thank you.
Go ahead, sir.
Thank you, Your Honor. Counsel's correct that there was a prior release, a prior lawsuit in Karnes County involving this piece of property, 637 acres, as a result of a pipeline rupture that was pipeline owned and operated by Blackbrush. That was on a separate piece of this ranch. It involved it was over, the acreage that involved is separate from the acreage involved in this release. So there were two unrelated incidents. There was no commingling of those incidents, and the cause of them are separate. And therefore, there is no commonality between those two injuries. And we are not seeking any damages against Intervest for anything that Blackbrush might have done. This solely relates to Intervest release of thousands of barrels of crude oil onto this piece of property. It was a separate lawsuit. There's no commonality of the issues. There's no commonality of the claims, Blackbrush versus Intervest. So certainly was not appropriate to disclose those in a request for disclosure because it wasn't a settlement in this cause because Blackbrush is not a part of this particular lawsuit. There was a settlement there. Our experts have acknowledged, and in their appraisal and in their report have acknowledged the prior release, so they have taken that into account. If counsel, when they depose him, want to ask what factors he took into account, he can certainly address because it's all laid out in his report. The prior reports, expert reports in the Blackbrush litigation versus the appraisal report, all of the environmental reports, all the environmental expert reports have been given to them so they know the full extent of any claims, any damages that were there. As far as cleanup standards and remediation, counsel is aware that those are set by the Railroad Commission. And they have full access, and we have given them what files we had on the Railroad Commission, but since it's open records, they have full access to the Railroad Commission files as to what cleanup standards the Railroad Commission is requiring for the black brush release, just as Intervest is having to go through the Railroad Commission to determine what standards they have to meet in order to get a closure of their particular release. So they are unrelated, and one is not relevant to the other. It's not going to shed any light on any issues in this case. We are subject to a confidentiality agreement. The only thing they don't know is whether or not any money exchanged hands between Blackbrush and Mr. Opiella, and if so, how much? That's all. That's the only information that they're really lacking. I will echo
Yes, sir.
what the Blackbrush Council is aware of this hearing, and they, as she said, have elected not to participate.
All right, and when was the Blackbrush litigation settled? If anyone knows offhand?
Oh, 2 years ago.
I would trust Mr. Grissom on that.
I think it settled in the summer of 2018, if my memory serves me correct, Your Honor.
All right, so about the same time, the incident in question. But let me ask, is there any real estate that you're asking compensation for, Mr. Grissom? In this case, that you also ask compensation for against Blackbrush?
Well, it is one ranch comprising 637 acres. So the Blackbrush contamination occurred on approximately 11-acre section or portion of it in a different area than where the Intervest release is, but it all relates to the same 637-acre ranch. So the expert's evaluation goes to the entire 637-acre ranch. If that answers your question.
Yes, sir. Anything else, Ms. Cover?
I'll have just a couple points in reply, if that's
ahead.
okay. I know that we're running late. Plaintiff's counsel, Mr. Grissom, has been calling this a separate piece of the ranch, but as we just discussed, the valuations that plaintiff's expert put forth in both cases apply to the entire ranch. So contamination anywhere on the ranch is relevant and key to those valuations. So while it might be potential theoretically in a different world to treat this as a separate piece of property, plaintiff's damages theory doesn't and makes this relevant. On the rules for disclosure that plaintiff's counsel brought up, those aren't limited to disclosing settlements that are only entered into in the prior lawsuit. It's all relevant settlement agreements. And as to the Railroad Commission, generally setting forth standards for remediation that could govern how the cleanup is done. Of course, parties can contract differently for higher standards of cleanup, perhaps. And so it would be important for a future property owner to know what those standards were contracted to in the settlement agreement. Thank you. And if you have any further questions for me.
All right. I've listened to the testimony carefully. I will order the production of the settlement agreement under the confidentiality agreement between the parties of all of it except the dollar amounts. And the reason I say not the dollar amounts is I agree there may be other things there that are completely relevant, but the dollar amounts go, I would say, to the value of the claim and not go to what they actually received for the claim and not its value. Maybe Mr. Opiella took 10 cents on the dollar because he thought Blackbrush was about to go broke and he thought he better get that. If that's true, he shouldn't suffer on this loss because he had to settle for so little last time. And maybe he got 3 times what he should have because Blackbrush was trying to close out all its operations down here and was selling out all of its holdings to Intervest. And if that's true, then Ms. Cover, your client shouldn't be punished for that by making it look like it's a lot more expensive to damage this property than it really is. So I'll order that everything except the dollar amount of the settlement be produced, and that way you can see if there is anything else about cleanup, about easements, about future operations out there. Okay.
Thank you, Your Honor.
Type up an order on that.
Right.
All right.
Who wants to do the order?
I can do the order, Your Honor.
Okay. All right. If you get it while I'm still online, you can post it in chat. Otherwise, if you would just e-file it.
All right. I think I'll be able to meet that deadline for posting in
Fine.
chat.
Thank you. Yeah, because I ought to be here a long time. And I said 1 o'clock, and the two of you are excused otherwise. Thank you.
Thank you.
And I said 1 o'clock, is that correct for, okay, man, 24 minutes for lunch. I don't know what to do with myself. Okay, I will see y'all at 1 o'clock. And I guess the Carnes, thank you. Y'all are excused.
Can I go over the docket with you real quick on 2 cases? Or would you rather not?
Because well, no, that's fine, but give me a moment because I closed them all out. Hold on.
If you want to send them to me, that's great.
No, I'll go over them with you so I have mine clear.
I had 2 in particular.
Sorry, I had to get a set for tomorrow, Letty. But I'm going to show you. I keep saying that. You ought to just get a buzzer where you can electrocute me whenever I do that. My brain is.
That's funny, Judge. It's because we've been receiving a lot of updates on the log.
All right. Send, Addis, what county you want to do first?
The LaSalle case, Judge, on page 3, the Candelario Elizondo case. I wasn't sure if that got dropped or if you granted the order.
No, reset on request.
Oh, it's okay. Okay, and then on the Wilson County case, page 1, the new res case,
Final judgment.
final judgment.
Yes. I signed that. I didn't send it to y'all, but I signed the hard copy, I believe.
Okay, that's fine. I think.
Electronic copy, I don't know.
Fine, let me see. Let me just make sure. And then on that, let's see. I think there's one other one. I'm sorry. The used car ones, did you sign an agreed order on that one?
Yes, it was a final judgment. It was an agreed order granting the summary judgment, so it's a final order.
All right, I think that's all I needed then. I think, because I knew they left, but I wasn't 100% sure. So now all we have is the Peeler case left. Is that correct?
Yes.
Okay.
All right.
Jennifer,
on the phone. I'll talk to y'all.
Thank you, Judge. This is just a test to see if my speaker's working. But it's not working on my end.
It's working.
Thank you, Judge.
All right, and I was able to download this morning from the link I received, the Peeler's response and KMG's reply, but I was not able to get the actual motion itself. I couldn't get it downloaded. Can somebody either post that to me in chat, or actually let me go back and I may be able to go to my Zoom and find it in the chat. No, it's not in my chat.
Would you like the brief, Your Honor, or the link?
Probably the link would be better. Whatever's faster. Is it 100 or 400 or 500 pages?
I don't recall how long the actual motion was. I don't think it's that long.
It looks like Mr. Schneider is just now connecting.
Right. Audio is still not working. There he goes. Mr. Schneider, can you resend the link? I was not able to get the actual motion downloaded.
Yes, Your Honor, I'll send it now. Give me just one moment. And if you like, I can send, if it's just the motion that you're missing, I can send that just via chat as well if you'd prefer.
Okay, if it's not too long, sure.
Okay.
I think Zoom is perhaps more robust than it was when we first started this, when people were trying to send several 100-page documents, it would hang up.
I think I've put the link up, but if Mr. Schneider wants to put up the actual brief.
Oh, yep, sorry. Let me just do that.
All right, let's see if it'll download. And now it's downloading. I couldn't get it to download the links earlier. I had to go and open them up and then scroll through until it opened the entire document, and then it would download. All right, give me a few minutes to look at this and I'll be right back.
Thank you, Your Honor.
Okay, who is going to argue for KMG?
Your Honor, Mark Guthrie for KMG.
All right. And all right, go ahead, sir.
Thank you, Your Honor. May it please the court. We are here on KMG's motion for summary judgment on the Peeler's tort and statutory tort claims. Can you see the screen share?
Yes.
Okay, thank you. This is a no evidence motion, and we believe that KMG is entitled to a no evidence motion for summary judgment, but the Peelers take nothing against KMG by reason of any of their tort and statutory tort claims. The Peelers fail to raise a fact issue as to the challenged elements of each of their trespass, negligence per se, and Natural Resources Code 85.321 claims. This motion presents grounds in addition to, but not in lieu of, the state action level motion for summary judgment argued in December, which was a joint motion. And that's presently pending before the court for a ruling. And it's not in lieu of the joint motion for summary judgment on limitations that has been filed and is set for hearing sometime in February. The state action level issues are intertwined with this motion. If the Peelers have to demonstrate a violation of a state action level or a properly calculated protective concentration limit, then they have no evidence of their claims here. And we also believe that the claims are barred by limitations, but again, that's an argument for another day. But simply, there are many good and sufficient reasons standing alone to end this lawsuit today as against KMG. Just for some background, the mine operation started in the early 1980s. KMG was the third contract mining operator from January 2011 to July 2020. KMG does not hold the mining permit. KMG is not the owner of the mine, and KMG is not the power plant owner or operator. KMG was never a party to any lease or contract with the Peelers. KMG did not mine on the Peeler Ranch. It's undisputed that the Peeler Ranch was mined out by 2004, some 7 years before we got to the mine. And there's some evidence in the record that Area A was mined out. Area A is the primary area that we're dealing with here, was mined out approximately 1990, approximately 20 years before KMG got to the mine. KMG did not perform any material reclamation work on the Peeler Ranch. Most of that reclamation, which includes refilling the mine pits, regrading, adding topsoil, and planting grass, other than the end pits that are still open and full of water, was done by the first and second mine operators while active mining occurred on the Peeler Ranch. And thereafter, reclamation on the Peeler Ranch was done by San Miguel or parties other than KMG. Because KMG was not actively mining on the Peeler Ranch, KMG did not manage ponds or pits on the Peeler Ranch or discharge water from them. Just additional background, the Peelers have agreed to dismiss with prejudice all of their claims against KMG for declaratory and injunctive relief, joint several liability, and vicarious liability, and we will have an order to you shortly on that. But since the Peelers never had a contract with KMG, all that's left is the Peelers' claims for the torts and statutory torts that they allege. The courts previously ruled, based on the economic loss rule, that the Peelers' remaining claims against KMG are limited to damage to non-lease property. That is, property outside the buffer zone lease that surrounds the power plant and property outside of the mining lease on the Peeler Ranch. And the Peelers must show causation and damages as to property on which there's no evidence that KMG ever operated on or physically entered. I want to show the court the...
Let me ask Mr. Guthrie, is there evidence that KMG may have allowed wind-blown ash or water and contaminants to have flowed or blown onto Peeler property outside of the buffer zone and the lease property?
We don't believe there's competent summary judgment evidence, and that's what we're here to talk about today. The Peelers have attempted to provide some evidence, but we don't think it is competent. And we will go through this issue of water-borne contaminants and dust-blown or air-blown contaminants shortly. But we don't believe that there is. That's not going to work. I'm sorry, I'm trying to put up. Cody, can you show the mine pond exhibit for us?
Yes, sir, I will. If you have to stop sharing first, and I'll be able to do it.
Okay. Thank you.
Should be on the screen now.
Okay.
Yes.
All right. Your Honor, if you will recall, we looked at this exhibit in one of the hearings last week, or a version of this exhibit. This one is the same basic exhibit, but we had a witness annotate some things on it. You can see where the power plant is within the yellow box, sort of in the center. Unfortunately, this map does not depict the buffer zone, but it surrounds the power plant. The buffer zone leases approximately 902 acres. The power plant site you're looking at is approximately 300 acres. There is an area that's labeled Ramp 10 Pit. We refer to that sometimes as in Pit 10. Ramp refers to a road that leads to the Ramp 10 Pit. This is one of the water-filled in pits that arises from the mining in Area A on the Peeler Ranch. It is the only in pit that is on the Peeler Ranch. The other two in pits, and you'll see below it the Ramp 8 pit, and then there's another one that is, I think, referred to as the Ramp 5 pit, are not on the Peeler Ranch. And this red line, Cody, if you can trace the red line, the property boundary depicts, he's highlighting it for you, it depicts land that is not on the Peeler Ranch. Okay. The haul road runs along, and Cody, could you run the cursor along the Hall Road from the plant? There you go. He's highlighting that in yellow. That roughly represents the area or the northern edge of the area that is subject to the mining lease and is part of the permitted area for the mine itself from that yellow line along the Hall Road down to the south. And we had a witness do some writing on it. And this witness was from North American Coal, which was the second operator of the mine. And he outlined, this part's a little bit hard to see, but he outlined in red Area A of the mine. And Cody, could you trace that for us? That's what he labeled. Let's trace the area that runs to the from the south of the power plant roughly to the east of the power plant.
Your Honor, at this time, I'll have to object. None of the testimony that Mr. Guthrie is referring to is in the record of either the motion or this case at all. And so
Your Honor,
repeating, or he's just.
Let her finish, Mr. Guthrie. Go ahead.
And so, so these descriptions of the map are to the extent they are being attributed to some witness, we don't have any of that in the record before the court right now.
Your Honor, this is just a demonstrative exhibit to give you a visual picture of what we're going to be talking about.
I'll overrule the objection. Go ahead, sir.
Thank you. So Mr. Schneider was in the process of outlining Area A. Okay. So as you can see, this Area A was mostly mined and reclaimed sometime between when mining started and 1990, give or take. And the year is not really important other than the fact that it was well before KMG got to the project. So this means that all this area, or most of this area from the Hall Road south to south of the end pit at Ramp 8 and the end pit of Ramp 10 had been excavated and then refilled with, and I think this part's undisputed, a combination of coal ash and what is called spoil, which is the part of the earth that is over and around the lignite seam. And it doesn't include topsoil, which is supposed to be moved off and stockpiled until the strips are filled in, the excavated strips are filled in. So all through this area, there is coal ash and there is mine spoil, and then it was covered by topsoil and grass was planted on top of it. And the same thing occurred up here to the northeast in Area B, which you can see is labeled, and if Mr. Schneider will trace around Area B roughly, that's part of another area that's in dispute, I guess, between KMG and San Miguel, but as far as I know, there have not been any allegations against KMG that really relate to Area B. Okay. We can go on now. Thank you. If you'll stop sharing and let me resume, Mr. Schneider. Okay, where did my...
Mr. Guthrie, you should be able to.
Yep, there it is. All right. Let's talk about the Peeler's response to the motion. It significantly misrepresents and mischaracterizes the evidence that they cite in support of their claims. And I'm talking about deposition testimony that doesn't say what they say it says. If this response was a fast food restaurant, it would be a Burger King because it is the home of a Whopper. It relies on late, conclusory, unsupported, and unreliable expert opinions that are not based on the proper standards to establish contamination. And by that, I refer to the state action level protective concentration limit issue. It relies on incompetent summary judgment evidence that KMG has properly objected to, and it fails to articulate the legal duties that the Peelers claim that KMG breached. It improperly attempts to rely on the contract between KMG and San Miguel to establish legal duties to the Peelers without any basis or legal authority. And it fails to provide evidence that raises a fact issue, competent evidence that raises a fact issue regarding the acts or omissions by KMG that proximately caused any damages to the Peelers. It also fails to raise a fact issue about damages. Because of this, we ask that the court review each deposition and source cited by the Peelers in considering this motion, and just not to take their word for what it says in the briefing about what a deposition says, because I'll show you some examples in a few minutes, but there are numerous mischaracterizations of testimony. We also ask the court, in ruling on this motion, to disregard the late opinions of Johnson and Brown, the Peelers experts, that are contained in their declarations that were submitted in connection with the Peelers' response to the motion. Disregard their contamination opinions based on the improper standard that is not a state action level or protected concentration limit exceedance, and that the court disregard their conclusory opinions that are based on many unsupported assumptions. And we've incorporated our reference to our motions to exclude Johnson and Brown. Brown, you've heard the argument on, you've heard the joint motion to exclude Johnson, and we still need to finish the supplemental motion to exclude Johnson. KMG, in thinking about this motion, KMG suggests that the court focus on KMG's activities and the Peelers' proof of causation. And I want to start with coal ash and dust. The Peelers at the outset present no competent summary judgment evidence that any coal ash or dust on the Peeler Ranch is harmful. The Peelers' testifying experts did no scientific analysis of this ash or this dust I mean, the ash is clearly available to the extent it's sitting in the pile. And it's also available to excavate the excavated area, or the formerly excavated area that we saw in Area A, to find out what is the composition of this ash or dust. The peelers testifying experts have no evidence, develop no evidence of how this ash reacts to surface water or groundwater, including the highly saline groundwater they claim is contaminated. We're not talking about groundwater that serves as a source for drinking water. The groundwater they claim is contaminated is unusable. And I don't think there's any dispute about that. So we're just to assume that the composition of this CCR or dust is bad. And there's no evidence at the outset that connects the dots to prove that ash on the peeler ranch or any dust causes the harm that the peelers claim. The peelers cite to the Federal Register regarding coal ash dust. And here's the language from their response. They say that the EPA has recognized, oops, sorry about that. Go back. They say that the EPA has recognized that fugitive dust from coal ash disposal at both landfills and surface impoundments creates an unreasonable probability of adverse effect on health and the environment if not properly controlled. If you go to this citation, it does not say that in these words. And the peeler citation continues, the EPA noted that absent controls, dust levels at locations near coal ash landfills could exceed the 24-hour particulate matter 2.5 National Ambient Air Quality Standard for fine particulates. There is a reference to that. Then they go on, EPA also found that excessive cancer risks are associated with the inhalation of hexavalent chromium in coal ash fugitive dust. If you go to that citation, it doesn't exactly say that. It refers to hexavalent chromium, but it doesn't refer to it in the context of coal ash fugitive dust. So this is misstated, this is mischaracterized. We object any consideration of the statement, even the one on the EPA website, because it's not properly authenticated and it's hearsay. It's not a determination, it's not a regulation. It's rather a writing explaining why the EPA chose a different way to regulate coal ash dust than was originally proposed by the EPA. And the peelers also failed to cite this part. Very few studies have been undertaken to test the health impacts caused by fugitive dust emissions. And of those few, due to inherent limitations, all failed to prove that fugitive dust was the cause of the documented health concerns. Continuing, the peelers also misrepresent the testimony of experts for San Miguel, KMG, and STEC to try to establish that coal ash generally causes harm. And then they cite the testimony of Mr. Meister at pages 11 and 12 of the response. And here's what they say. He said, coal ash contains an increased concentration of metals and other constituents found in lignite that have caused damage to human health and ecosystems, and water flow is a mechanism for transporting these contaminants. Well, if you go look at that testimony, Mr. Meister was testifying about a collection of unrelated statements that he was being asked questions about from a report that Mr. Meister had relied on for his report in this case. These weren't his opinions. He was talking about statements out of a report. He was answering questions about statements out of a report. And at most, when you read that testimony, he testified that if constituents of coal ash are improperly managed, they can cause concern. And he also said that the cases cited in the report he was being asked about don't come from SMECRA permitted coal mines. They involve coal ash someplace else. Let's talk about what they said about Powell, another expert for San Miguel, KMG, and STEC. They misrepresent that testimony too. And on top of that, the testimony is irrelevant, fails to create any fact issue about harmfulness of coal ash or anything else. They say that counter defendants designated expert on coal ash impoundments, explaining that numerous toxic constituents of coal ash can leach into water. If you look at his testimony, it doesn't say toxic constituents. It says, but they can become constituents of concern. And by constituents, he's referring to constituents of coal ash. But this is not his testimony as they have portrayed it. They also cite the Powell's deposition on pages 44 and 45 for confirming instances of toxins from coal ash waste migrating in water beyond the boundary of the coal ash management unit. Again, this testimony doesn't say, Mr. Powell didn't say toxins. He said constituents of concern had migrated beyond the boundary of a coal ash management unit. But let's see if we can get it advanced. I don't know why it keeps backing up. So there's really no competent evidence that alleged KMG mishandling of coal ash allowed water to transport contaminants off the lease premises at this site. There is no evidence that any leachate from coal ash placed in the pile at the in-pit 10 on the Peeler Ranch or any dust contaminated Peeler Ranch property off of the mining lease, or for that matter, on it. The closest location to in-pit 10 off the mining lease is up above the haul road we looked at. It's at least approximately 3,500 feet over the ground, 2/3 of a mile in the northwest direction across the haul road, above the haul road. And if you look at a track map, it's diagonally across at least 4 10-acre tracts. There's evidence that the Area A seeps off of the leased property started by 2004. KMG was not there. Wouldn't be there for 7 more years. And that's significant for a number of reasons, but mostly causation. If there were already seeps off of the leased property, what was causing it? And I will submit to you that it's very likely, and I think there's expert testimony in the record to the effect that there were seeps of water that were through the mined area that is north of N Pit 10 that was mined and reclaimed by others.
Your Honor, again, I'm objecting because Mr. Guthrie has not provided any of the testimony he is describing. None of this is in the record or attached as evidence to their motion.
Actually, it's in our reply, and we'll get to it, Your Honor.
I'll overrule the objection for the time being.
The Peeler's experts' conclusions to the contrary are unsupported by any scientific analysis of migration. And by that, I mean, to the extent that they claim that Kiewit Mining Group did or did not do something to cause coal ash from the pile at N Pit 10 to get in the water of N Pit 10 or otherwise, or to somehow get into the groundwater, whether it was through the bottom of N Pit 10 or some other way, and migrate at least 3,500 feet off the mining lease through this groundwater. They have not done any technical analysis to show how far a constituent of coal ash migrates, how fast it migrates. And again, it has to go through this area that was previously mined and reclaimed and had already started seeping by 2004. The Peeler's experts do not connect these dots. What they say instead is, well, we did samples of an area off the mining lease and we detected an exceedance of boron in the groundwater. This is also a marker for oil field produced water. But they say if there's boron, there is coal ash contamination based on their definition. They did no scientific study or investigation that demonstrates that ash or runoff from the ash pile at N Pit 10 is contaminated. We've already talked about that. Or that it runs off into the N Pit, the water in the N Pit, or somewhere on the surface. Or that it gets into the groundwater, which is, again, unusable in this aquifer or these aquifers, or that it causes actual contamination of the groundwater, defined as an exceedance of a state action level or a properly calculated protective concentration level, that it travels through the mine spoil for that at least 2/3 of a mile, that it daylights. Now this is coming up from the groundwater, that it comes back up to the surface, with contamination or bringing contamination with it at any sample location. There's no evidence. They claim that KMG mishandled coal based on a mischaracterization of KMG or a KMG witness's testimony that was started by Brown, I think. And if you'll recall at the hearing on the motion to exclude Brown, we looked at Mr. Zulu of KMG's deposition testimony. We'll talk about that more in a minute. But the Peelers claim that KMG's intentional acts of handling coal ash such that it was exposed to the wind, rain, and groundwater were practically certain to cause coal ash contaminants to enter into the Peeler off-lease property because groundwater had previously infiltrated the dewatered end pit, and this refers to end pit 10, where KMG heaped ash, and KMG was aware of the seep problem that had been plaguing San Miguel since 2004. This is the Peelers saying this. And they cite Mr. Zulu of KMG deposition testimony. If you look at that site, his testimony shows that he was not testifying about what KMG was aware of, but instead about his potential lay witness testimony and what the Peelers may have known as a result of prior activities in the permitting process that he was aware of before KMG's arrival. The Peelers also alleged in their response that KMG constructed an earthen land bridge across the flooded pit 10, and that one cell was emptied by pumping the water across the land bridge into the other, and that KMG did nothing to ensure the structural integrity of the land bridge it created. If you will recall, at the hearing on the motion to exclude Brown, this is where we looked at what Mr. Zulu's testimony was about the construction of the land bridge and whether or not KMG put ash into a dewatered portion of End Pit 10, which the Peelers and Mr. Brown claimed that they had, and which Mr. Zulu's testimony established they had not. And here it is again. They re-upped or doubled down on this assertion. KMG subsequently filled the dewatered cell in adjacent areas with the plant's coal ash waste. And they cite the same testimony and this testimony stands for the proposition that KMG added ash to the ramp 10 pile, the pile adjacent to ramp pit 10, not inside the pit itself, at San Miguel's direction in 2012, 2013, 2014, 2015. And then sometime in 2016. Then they say KMG has conceded that liquid runoff from the adjacent ash piles may have ended up in ramp pit 10. I'll skip over the material about Brown's late filed declarations containing this assertion about the land bridge and emptying the cell and filling the dewatered cell, because the court's already looked at that. This is not what Mr. Zulu said, but again, the peelers cite it as evidence. Zulu also made no concession about the runoff, as the peelers claim in their response. But even if this claim was true, there's still no causal connection that's been demonstrated between ash in the ramp 10 pile to off-lease contamination. But please don't take me wrong. This is not true. This claim is not true. KMG put ash on top of the pile, not in the pit. The peeler's own summary judgment evidence shows that ash was buried in areas A and B as part of the reclamation process, which is what I was referring to before in connection with that exhibit. And they cited Mr. Kezar's deposition as the general manager of San Miguel, who explained that coal ash was placed in most of the pits in area A and all of the pits in area B. Now, let's talk about Mr. Zulu's actual testimony about runoff, where they just represented in their response that he conceded. Here's what he actually said. Do you agree that the ash in ramp pit 10 is in contact with the water in the pit? Answer. There's runoff from those ash areas that is collected in the ponds nearby pit design. I cannot rule out that runoff may have ended up in ramp 10, not sure. Question. My question is not specifically about runoff. My question is whether or not the ash that's in the ash pile at ramp 10 is in contact with the water. His answer was, my understanding of how what is in ramp 10 is there's a separation or plug between where there's water and the area where ash is placed. And it's underneath the top, which I believe he corrects to the bottom of where the ash is. That is meant to keep the ash from running into the water. So what he's trying to say there is that KMG took steps to prevent ash from running into the water, and that arose from the construction of this land bridge. It wasn't a mechanism for KMG to put ash into the end pit itself. And then he says that is not to say runoff does not get into the water. He can't rule it out, as he said up above. But that's not a concession, as represented. The peelers also claim that KMG did nothing to ensure that the ash from the ash pile at pit 10 was not mixing with the water on the other side of the pit or the land bridge, and didn't even monitor the situation. Now, this claim is sort of a gotcha, when did you stop beating your wife type claim. And I'll get to that in a minute. The purpose of the land bridge was to provide additional separation from water in the end pit. The release of the retained wastewater that KMG had contaminated was entirely foreseeable, and I'm back on a peeler claim now. They claim that KMG knew that the ponds would have to be dewatered, and releasing the water across the surface was the most direct way to do this through the permitted discharge point, but they offer no citation to any evidence supporting any of this assertion. Now, the simple answer is that maintaining, and the correct answer, is that maintaining and managing in pit 10, which was full of water and created by others when KMG started at the mine, and maintaining and managing the relevant mine ponds on the Peeler Ranch was not within KMG's scope of work. And there is no evidence that it was. So KMG didn't really have a duty to ensure that ash from the ash pile at pit 10 was not mixing. Didn't have a duty to monitor the situation. This issue about releasing the water across the surface was not within KMG's scope. This was all these were all things that were handled by San Miguel because there were no active mining operations on the Peeler Ranch during KMG's tenure. There's no evidence that any alleged KMG mishandling of coal ash allowed water to transport contaminants off the lease premises, whether on the surface or through groundwater or any other way. There's no evidence that KMG buried any coal ash in any mine pits on the Peeler Ranch. The prior contractors did all that. The citation to the Powell testimony, again, one of the experts for San Miguel, KMG, and Steck, doesn't support any scintilla of evidence that KMG caused transport or contamination to off-lease premises property. Powell's testimony was not about the Peeler Ranch. He was talking about unlined ponds, not mine end pits, and he was talking about them in the context of prior projects that he had been involved with elsewhere. At best, Powell's testimony establishes that coal ash, when in contact with water, has caused contaminants to move. I left out some words on the slide. I apologize about that. Elsewhere, and if you look at his testimony, he talks about prior contamination of groundwater on another site. He was not testifying about ponds, but burial in mine pits. And the one circumstance he discussed where the coal ash went in contact with the water and migrated was due to site-specific issues at that site. It's not a given generally. And that makes sense because it depends on the geology of whatever the groundwater is moving through. It depends on the groundwater itself. It depends on head pressure that moves groundwater. Depends on all kinds of things. But it doesn't support any inference that occurred here as a result of anything that KMG did or didn't do at Pit 10. Now, again, the Peeler's own evidence shows that groundwater was infiltrating coal ash and mine spoil buried long before KMG's time and then seeping into off-lease land. And you can see that in the Brown report, a chronology in the Brown report. but the peelers present no competent evidence of any KMG or involvement in or responsibility for this. There's no evidence KMG discharged mine or other water to off-lease property. You've heard a lot. I'm sorry, I didn't mean to do that. You've heard a lot about these massive, at least claimed by the peelers, discharges of water from areas on the Peeler Ranch. And one of those was around the time of the TRO hearing. And one of those was a few months before the lawsuit was filed. And I believe there's evidence of another one in 2017 sometime. KMG had nothing to do with that. There's no evidence that KMG did. KMG does not discharge water anywhere on the Peeler Ranch, did not discharge water anywhere on the Peeler Ranch, other than to the extent it does dust suppression on roads in areas that it operates on. And there's no basis for any assumptions of experts that KMG did. But there are assumptions in both Johnson and Brown's report that San Miguel and its mining contractor discharged water. And those are incorrect. And those assumptions, as we've set out in the motion to exclude Brown, and will complete in connection with the motion to exclude Johnson, makes any of their opinions about KMG's participation in water discharges unreliable.
And are you, is KMG and the peelers using the same definition of discharge? It seems to me that KMG is arguing that if there's not a fire engine sort of pump running huge amounts of water into the creek at one time, that it's not a discharge. And I'm wondering if it's just leakage or runoff that has contaminants, would that still be discharge?
I am referring to intentional discharge here.
Okay.
And intentional discharges of large amounts of water. As for leakage or runoff, the mine by design is required, and by permit requirements, by governmental requirements, it is required to be closed in terms of a loop for water that at least travels along the surface. There are only permitted discharge locations, and those are controlled by the regulatory authorities in terms of the permits. KMG did not get involved with that on the Peeler Ranch because it wasn't actively operating. San Miguel maintained control of water and discharge and the like. But to answer the court's question, when I'm talking about discharge, I'm talking about the pump or the fire hydrant type discharge here. All right. There's no evidence that KMG should be responsible for any discharge of water by San Miguel or others. Now, the peelers claim that KMG is a multinational company that purports to be an expert in mining and reclamation, and thus it should have known that the manner in which it handled coal ash at the plant on the peeler premises risked contamination. That's not supported by any citation to any evidence, and is really nothing more than speculation and an unsupported conclusory opinion that assumes facts not in evidence. There's nothing in the record that shows what KMG knew or should have done. There's no evidence to support the peeler's claims that KMG's ash handling at the plant caused off-lease contamination. And if the court will recall, we looked at some deposition testimony, again, in connection with the motions to exclude Brown, where Mr. Brown had gotten a hold of some emails in 2015 or 2016 in which San Miguel was complaining that KMG was not timely removing coal ash from the power plant site. And the email indicated that they didn't want it to cause any kind of environmental issue by getting into the drainage system. Now, setting aside the fact that KMG disputes that it was not performing timely or there were not reasons for it to not perform timely, Mr. Schilling, who was the environmental manager at San Miguel at the time, who authored these emails, testified in his deposition that this situation caused no environmental issue that he was aware of. And he said that as plainly as he could. He's no longer employed by San Miguel. I believe we took his deposition in Beaumont.
Again, Your Honor, I object. They have not attached this evidence about Mr. Schilling's testimony to either their motion or reply.
It's included in the motion to exclude Johnson and Brown that we incorporated into the reply, Your Honor.
I will overrule the objection. Go ahead, sir.
The peelers nevertheless say KMG's poor coal handling practices at the plant, as documented in contemporaneous San Miguel emails, allowed ash to build up and be washed into drainage ways, thereby causing contaminants to migrate off the plant property and onto the peeler's off-lease land. And here we're talking about the power plant, and Mr. Schneider, I'm going to stop sharing my screen, and if I could get you to put up the document that we have that shows the location of the ash pile, I'd appreciate it. Let me get to.
All right, and I'm sorry, I need to take.
Did anybody hear how long the court said he would be gone?
No.
Guthrie, I muted you. I was trying to unmute myself. All right, I have something that's come up I need to take care of. It's probably going to take about 20 minutes, so we'll call it 2:30 and we'll come back and hopefully get this finished up in one go.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
All right, I'm back. Hopefully I can get through this with no further interruptions. Go ahead, Mr. Guthrie.
Thank you, Your Honor. I'd like to ask Mr. Schneider to put up an image of the plant site so that we can see where we're talking about in connection with this claim that ash handling at the plant caused off-lease contamination. And if Your Honor will, are you able to see this image of the plant? Okay. This image came out of Mr. Brown's files, who's responsible for this claim, at least in terms of the way the peelers cite to it in their response.
Again, Your Honor, I have to object because this was not attached to their motion or reply and is not part of our evidence. If he wants to use this for demonstrative purposes, that's one thing, but this, the claim that this is Mr. Brown's image is more what I'm objecting to.
Well, I'll make that representation to the court, but I am using it only for demonstrative purposes, Your Honor.
Go ahead then.
Thank you. If you can see in the upper left-hand corner, the ash pile label.
Yes.
That is where the ash pile is. You can see to the left of that a road, actually a couple of roads, just to the left of the ash pile, that dark area, that's the lignite pile. And then the ash pile is a little bit further to the right. You'll recall that there's a buffer zone lease that covers property about 3 times the size of the plant footprint that surrounds the plant. And again, this claim is based on Mr. Brown's review of emails from Mr. Schilling and his reading of part of Schilling's deposition testimony. And notice that the claim is, thank you, Mr. Schneider, let me go back to mine.
And being in New York.
Your Honor, can you see the slideshow again now?
Yes, but I zoomed in. Let me zoom back out so I can read it. All right, go ahead.
All right. Notice that the claim is allowed ash to build up and be washed into drainage ways, thereby causing contaminants to migrate off the plant property and onto the peeler's off-lease land. Now, this opinion ignores Mr. Schilling's testimony that I referenced, that no environmental issue was created by KMG's activities referenced in the email, and Mr. Brown's assumptions otherwise are unsupported. He does no work and did no work to determine that the ash got into the drainage ways. He did no work to determine that the ash left the site. He did no work to determine that the ash, if any, that left the site left the buffer zone. And he doesn't connect the dots between any elevated level of anything and this alleged delay in removing the ash on this day that's referenced in the email or any other day, and any spill or emission of any contaminant on the non-leased area. Now, he testifies in one of his late filed declarations that this caused or contributed to contamination, because about 2 years after the email in question, there was a discharge from the plant's equalization pond. And as Mr. Brown vaguely phrased it in his late filed declaration, the discharge flowed toward South Creek. Now, Mr. Schneider, I'd also like for you to share your screen again and show the other image of the plant. So we can see where we're talking about. Okay. Again, where the red circle is the ash pile. All right, and let's go to the right side of the image. And the equalization pond is all the way on the other side of the project. So there are a lot of assumptions in there about getting into drainage ways, getting into equalization pond, flowing toward South Creek, and a conclusion that have affected the off-lease property that are just completely unsubstantiated and not supported by any analysis. There's no evidence that the discharge referenced or reached or impacted any area outside of the buffer zone. Now let's move to wind and water transmission of toxins as claimed by the Peelers. The Peelers assert that Alonzo Peeler recounted seeing dust blowing off the Hall Road, leading to contamination of the water on the Peeler property. And they cite Mr. Alonzo Peeler's deposition. We've objected to most of that deposition site because it contains hearsay and it's non-responsive, and there's a lack of foundation and speculation in that testimony. Mr. Peeler's testimony was not about recounting seeing dust blowing on the Hall Road, leading to contamination of the water on the Peeler property. Instead, it was about Mr. Peeler's prior discussions with a company that does, according to his words, does tanks and fish, called Clearwater. It's completely inadmissible. It repeats what the Clearwater representative said to him. So it's hearsay concerning purported water contamination to an unspecified tank in an unspecified location, and concerning the cause of the contamination. We'd ask the court to review our objection here and just disregard Mr. Peeler's testimony that was cited in support of dust blowing off the Hall Road. And again, it's really not probative of any issue on off-lease property because the location was never specified. The Peelers also point to Jason Peeler's deposition as establishing windblown, quote unquote, toxins. They allege that he testified to seeing accumulations of fugitive dust in numerous areas, noting, quote, it seems to show itself coming off the piles after it's dumped on the grass fences next to the road. And he also talks about seeing coal ash dust flying off the back of KMG's haul trucks, where he doesn't really specify the location. And recall again that, you know, the entire time that KMG was working at the project at the mine, it was mining off lease, off the Peeler lease, off the Peeler Ranch. So we don't know where he saw this coal ash dust flying off the back. There's an objection to part of this testimony that we've asserted. And again, the court should disregard it because of his answers about spreading toxic carcinogens through groundwater from the ash pile. And he makes a conclusory statement about the value of the ranch for which he lacks competence. The court and foundation, the court will recall on the motion to exclude ash evidence from yesterday or the day before, where Mr. Schick showed you that Jason Peeler testified in that deposition that he didn't have any opinions about the value of the Peeler Ranch. This evidence is not probative of any impact on off-lease property, and it's just no evidence of wind transmission of alleged toxins. Peelers also claim that Josh Coleman, who works for the Peelers as a ranch foreman and lives on the Peeler Ranch, testified that he'd seen dust from the pile where KMG deposited the plant's coal ash blow off the pile and across the ranch, including into his house, where his wife and 2 young children also live. Now, Mr. Coleman testified that this ash was from a pile at Ramp 7 on San Miguel property. He testified that he does not see or did not see ash blowing from the pile at Ramp 10, which is adjacent to End Pit 10, that's on the Peeler Ranch. And there's no summary judgment evidence that KMG ever placed any ash at what he was referring to as Ramp 7. So then there is the requirement in the Civil Practice and Remedies Code about there needing to be actual and substantial damage to establish harm from dust-borne contaminants. The Peelers state that KMG cites no precedent applying Section 75 of the Civil Practice and Remedies Code and cite a Fifth Circuit case that says that there's no requirement of actual and substantial injury to recover for damages from fugitive dust. They cite the Texas Stevenson versus DuPont case out of the Fifth Circuit in 2003. Now, first of all, there's no evidence that the dust here is harmful, no evidence in the summary judgment record. There's no expert analysis of any migration of dust anywhere. And there's no evidence of any injury that's due to dust, much less actual and substantial injury. To respond to the Peelers' claims in their response, the statute that requires actual and substantial injury in the Civil Practice and Remedies Code was amended after the DuPont decision the Peelers rely on to add that requirement in response to that decision. And we cite some secondary authority in the reply for that proposition. The Peelers also claim that by its plain language, Section 75.002 applies only to the liability of an owner, lessee, or occupant of real property. And KMG, as a mere contractor, with no right to occupy any relevant property can't satisfy this threshold. Well, that's just plainly not true. I mean, KMG is clearly an occupant of the property, or was during its tenure under its contract with San Miguel. So actual and substantial injury. There's no evidence of any injury at all here due to dust. Yeah, even Mr. Coleman wasn't claiming that it caused him any kind of personal injury, and there are no claims for personal injuries in this case. So what was the substantial and actual injury to the peeler's off-lease property due to fugitive dust? There's no competent evidence of causation due to any act or omission of KMG generally. The peelers cite to deposition testimony from Eric Matzner, who was a consultant for San Miguel, as proof that KMG's handling of coal ash somehow caused the peelers' alleged injuries. The peelers assert in their response that Matzner testified that his data indicates that water is flowing through the spoil on the Peeler Ranch. Mr. Matzner made clear elsewhere in that testimony that these were his conclusions from 2004, and that groundwater has been infiltrating the spoil since at least 2004. And that spoil, again, is the spoil that's north of the end pit 10 in the area of Peeler Ranch that had been mined. Groundwater had already infiltrated that soil. So it wasn't really a new rush of groundwater 7 years later, or more than that. Mr. Kezar's testimony doesn't support causation as contended by the peelers. He talks about groundwater in contact with ash that San Miguel and its mining contractors placed in the bottom of the Peeler mine pits, and confirmed, according to the peelers, that coal ash is distributed throughout the spoil used as fill in Area A. That's the peelers' evidence. The Kezar's testimony shows, if you read it, he was not confirming that coal ash was in contact with spoil, but instead noting to the best of his knowledge there was ash placement throughout Area A, and he did not testify that groundwater was in contact with the ash that San Miguel and its mining contractors placed in the bottom of the Peeler mine pits, but instead he had no reason not to believe what Matzner was suggesting about the groundwater. Again, not probative of any issue related to any action, omission, or causation by KMG. Now, let me shift back to the expert Brown. The peelers rely on several late declarations of Brown with unreliable new opinions that are not competent evidence of causation. We've asked the court to disregard those in our objections. He has a December 7, 2020 declaration where he claims that KMG had a well-defined role in creating a source of contamination impacting the Peeler off-lease property. And that paragraph from his declaration in December quotes paragraph 20 of his July 14, 2020 declaration, which is also late and untimely. That was the subject of our objections to those late declarations that were filed December 9, 2020. And Brown's again, July 14 declaration refers to the Area A final pit, the Ramp 10 pit, and this issue of the land bridge that we've already talked about before. This demonstrates the unreliability of his opinions where he completely misquotes Zulu's testimony. And the basis for KMG's well-defined role is conclusory, wholly, and unreliable. Brown also says the groundwater flowing through this coal ash will dissolve COCs and transport those away from the Ramp 10 pit, down gradient beneath the lease area, and beyond the lease boundaries. This statement is conclusory. As I said at the beginning, he does no scientific analysis to demonstrate this or test this. And this statement lacks proper support. It lacks any support, and it's unreliable. And because these assertions are unreliable, in addition to being late, they should not constitute competent summary judgment evidence, and the court, we submit, should not consider them. We've also asked that the court exclude all late filed declarations as untimely, and the peelers can show no good cause for late disclosure. And along that line, the court's agreed scheduling order in this case called for initial disclosures of expert opinions and reports by January 31st, 2020, and rebuttal expert opinions and reports by sometime in March 2020. And the declarations of Brown that we're talking about, one he signed in, one was dated in May 2020, but he didn't sign it until June 2020. And then you have the July and the December declarations, all of which contain new opinions to some extent that weren't originally disclosed timely. And just like this ash removal evidence that we heard about yesterday, or the day before, I'm sorry, I keep saying yesterday, it's untimely. We can't test it, discovery. It's unfair, it's prejudicial. And the peelers have never made any attempt to show that it's not prejudicial. They have the burden of doing that, and the court should just exclude them as summary judgment evidence. Now let me move to the peelers' trespass claims, and this is just what their claims are, as well as our no evidence points. No evidence that KMG without authorization entered or caused something to enter on the property owned by the peelers outside the leased property. No evidence that KMG intended to commit an act that violated the peelers' property rights as to land outside the leased property, or that KMG's actions would be practically certain to have that effect. There's no evidence that KMG's alleged trespass proximately caused an injury to the peelers to warrant the damages sought by the peelers in this lawsuit. And there's no evidence of the actual and substantial damage required by the Civil Practice and Remedies Code that we talked about a few minutes ago. The peelers' specific trespass allegations are that KMG stored and disposed of coal ash waste on the peeler ranch, resulting from lignite mined from off-track properties. Now that claim itself is barred by the economic loss rule, just the fact of storage on the peeler ranch, without more. Allowing fugitive dust from waste piles at ramps 8 and 10 to blow onto the Peeler Ranch, allowing leachate from waste piles at ramps 8 and 10 to run onto the Peeler Ranch, failing to maintain the ponds in the Area A mine area such that wastewater seeps into the soils and groundwater on the Peeler Ranch, failing to remove ash from the plant such that the ash builds up and gets into the drainage ways that run onto the Peeler Ranch. A lot of these claims relate to duties that KMG did not have under its contract with San Miguel because of the fact that KMG was not operating on the Peeler Ranch except to a very limited extent. Under its contract with San Miguel, which also required an approved annual budget in which KMG scopes of work and areas of work were set out, KMG did not have the obligation at ramp 8, which is on San Miguel property, or at ramp 10, which is on Peeler property, to perform dust control on those coal ash piles, except when it was actively operating on the Peeler Ranch or at ramp 8. After it finished actively operating, which was, at least in the case of Input 10, sometime in 2016, it had no obligation to, for instance, spray water on the ash piles to perform dust control. And there's just no basis for this claim other than looking at the San Miguel contract, and I'll talk more about that in a minute. The same issue relates to allowing leachate from waste piles to run onto the Peeler Ranch. San Miguel controlled all that. And I'm not saying that that happened, but what I am saying is that KMG was not in control of that. Failing to maintain the ponds in the Area A mine area. Under KMG's contract with San Miguel, the only obligation that KMG had as to ponds in the Area A mine area on the Peeler Ranch was to perform what are known as MSHA inspections. And those require MSHA certified inspectors. And those are limited to things like the pond level and the integrity of the embankments surrounding the ponds. That's not all of the things, but they don't involve underwater inspection. They don't involve determining if a pond is leaking. Unlike ponds in the areas in which KMG was actively mining, KMG did not design or construct these ponds and didn't have the duty to maintain them. We've already talked about this failing to remove ash from the plant. Let's talk about the Peeler's negligence claims and KMG's no evidence points or challenges there. No evidence KMG had a legal duty to the Peelers and KMG breached that duty, and no evidence that KMG's breach of any legal duty owed the Peelers approximately caused damages to the Peelers' property outside of the leased area. The Peelers point to duties arising from the contract with San Miguel, and that does not create evidence of any valid duties that owed the Peelers. The Peelers cite no legal basis to impose duties that KMG owed or may have owed San Miguel under its contract to the peelers. As I indicated before, the peelers ignore that some contract duties only apply to areas that KMG was actively mining on. And the peelers ignore that KMG's scope of work was limited by an approved annual budget. I mean, KMG's work was in effect cost reimbursable plus a fee. And if San Miguel decided that it didn't agree that KMG was supposed to do a particular scope of work, San Miguel would not pay KMG for that work. So it didn't have a general keys to the mine portion located on the Peeler Ranch to operate and maintain in its discretion. There's no evidence that it did. Now, the peelers in their response articulate only, besides these contract duties, a duty to act reasonably. And they cite no authority for that. And they have a fundamental misunderstanding of tort law. There's not a general legal duty to all other people to act reasonably. Now, somebody in Maine or California can't force a general duty on you or me to act reasonably without more. And there might be some common law duties out there that the peelers could have pointed to, but didn't in this response. They just referred to a general duty to act reasonably. So they failed to articulate legal duties that are valid or breach of those duties and rely on this contract they're not a party to. Some of these contract duties are KMG shall take all reasonable measures necessary as required under the relevant permits, leases, or government regulations to ensure that water quality in the vicinity of the project is not degraded. They incorrectly state that the agreement requires that KMG comply with the mining lease. They point to dust control as required. They point to, in no event shall contractor allow spoil to be placed in or contaminated water to be discharged into any area that will pollute a natural stream or body of water. And they point to maintaining all water control structures in a condition that will meet all regulatory requirements and conducting all required pond inspections. Now, in the abstract, that all sounds good, but they forget about KMG's limited scope of work. And in areas where KMG is actively operating a mine, not here. And this language creates no duty to the peelers and certainly no elevated duties. Yet it sort of flies in the face of the ruling and the rules related to the economic loss rule, where people who have contracts with one another owe their duties to those with whom or which they contracted, and third parties can't force them. Now, here's some other things that the peelers claim that KMG didn't do in their response. KMG did not do anything to monitor or ensure the structural integrity of the ash pile. So where was KMG's duty to do that? And the answer is they didn't have one. And there's no basis to assert one. What they cite here is that an employee, Kirk Rich of KMG, in his deposition was asked the question, did KMG do anything to monitor or ensure the structural integrity of the ash pile? The answer was no, they didn't. It was not their role. The peelers say that a photograph authenticated by San Miguel's fields manager demonstrates that the ash that KMG disposed of at pit 10 remains open to the elements, and there's nothing to prevent the ash from infiltrating the water. Well, that's not entirely true because of the land bridge, but there is a pile of ash there, and it is open to the elements, but it's not KMG's ash. KMG was just the laborer who deposited ash at that location at the direction of San Miguel. And it's San Miguel's ash, it's not ours. The peelers claim that according to Jay Johnson, another KMG manager, KMG also did not perform any work to maintain or monitor the surface water in the pond areas around pit 8 or pit 10, or to suppress dust blowing off the coal ash pile next to ramp 10, except when KMG was actively hauling ash to that pile. That's essentially true, but they didn't have a duty to. They didn't have an obligation to under their contract with San Miguel. And Mr. Zulu testified that KMG's scope of work regarding groundwater managing, sampling, testing, and monitoring was limited to areas in which KMG was currently operating, mining, because other than the MSHA pond inspection, each of those does not happen on areas that have been reclaimed and handed over to San Miguel. There's no evidence in the record controverting that. In our reply, we cite Mr. Zulu's testimony that end pits, including at ramp 10, are not permitted ponds. So KMG did not even have the responsibility to perform the MSHA inspections on them. Here's some more things that the peelers try to raise. We didn't perform any work to ensure water quality on the Peeler Ranch was not degraded. It was not our role. It was not our obligation to San Miguel. Under its agreement with San Miguel, KMG was responsible for the ponds in the permit area, including periodic inspections for pond integrity, vegetation growth, and tracking water elevation. Part of that is true, but it's limited to the inspections required by the MSHA inspection and not the underwater pond integrity. They say that other than a cursory visual inspection, KMG did nothing to determine whether there was seepage from any of the ponds. And again, San Miguel was responsible for the areas of the ponds that are not visible to the eye and not KMG. What the peelers refer to as the cursory visual inspection is the MSHA required inspection. And they complain that nor did Kiewit ever monitor the groundwater wells or review any reports generated by others concerning the groundwater wells associated with mining operations at the ranch. San Miguel was responsible for monitoring the wells, not KMG. And this is in testimony from Mr. Zulu. And again, KMG's scope of work regarding groundwater was limited to areas in which KMG was currently mining. Let's go over the peelers' negligence per se claims. They claim we violated statewide Rule 8. No person conducting activities subject to regulation by the Railroad Commission may cause or allow pollution of surface or subsurface water in the state. a requirement to prevent water from coming into contact with acid forming and toxic forming spoil, a requirement to prevent, minimize, and treat water pollution, and a requirement that prohibits the collection, handling, storage, processing, or disposal of industrial solid waste in such a manner to cause the discharge or imminent threat of discharge of industrial solid waste into or adjacent to the waters in the state, the creation or maintenance of a nuisance, the endangerment of the public health or welfare. The peelers don't advance any evidence that KMG, any competent summary judgment evidence that KMG violated any statute or ordinance listed above, or that any such violation caused or proximately caused any damage to the peeler's property outside the leased premises. We deny all that. That is set out generally in the reply, and I'm going to leave that for the court. The peeler's Natural Resource Code 85.321 claims fail for the same reasons. There's no evidence that KMG's actions or omissions violated any conservation law of the state or a railroad commission rule or order. No evidence that each alleged breach of a conservation law or the railroad commission rule or order caused or approximately caused any damage to the peeler's property. The peelers claim generally that their expert reports establish presence of contamination that precludes summary judgment, and other evidence establishes that KMG was responsible for introducing coal ash whose toxins migrated to off-lease locations. They cite their experts Johnson, Brown, Baumann, and Ross. Now the court's already ruled that Baumann's opinions, and recall he was the geophysical electroconductivity expert, that those are excluded as against KMG. As set forth in the motions to exclude Johnson, Brown, and Ross, the opinions, all of their opinions about contamination are based on the incorrect standard rather than the exceedance of a state action limit or a protective concentration limit, and should be excluded. The opinions are unreliable as they don't validly trace any activity by KMG to purported contamination. And to the extent they mention what KMG did or didn't do to cause alleged contamination, they're conclusory and contain many, many unsupported assumptions. And those opinions should be excluded as set forth in the various motions. I want to talk about the peeler's response to causation for a few minutes. They make this claim based on a case that since KMG allegedly commingled ash with ash handled by San Miguel or prior mine operators, it has the burden to distinguish the ash that KMG handled, and that if it can't do so, Texas law makes KMG legally responsible for all injury caused by any coal ash toxins that entered the off-lease peeler ranch acreage. The only case they cite for this proposition is Humble Oil versus West, which is a 1974 Texas Supreme Court case. the case is inapplicable to tort claims and damages, and it deals with proving ownership of and rights to commingled goods. The case actually involved Humble, who was obligated to pay royalties on gas to West for certain gas, and Humble actually injected gas from another source into the same reservoir to store it. And West decided that even though the gas from this other reservoir or this other source wasn't from West property, that West was entitled to full royalties on it because it would subsequently come out of the reservoir. And again, the courts have applied this theory only to determining disputed ownership or rights to goods. It's not applicable to tort claims and damages. We cite a number of cases in the reply that I will commend to you. It is counter to well-established tort law in Texas. The peelers have the burden, notwithstanding their commingling claim, of establishing not just that they were injured, but that KMG's acts or omissions caused that injury. We set out the elements of proximate cause. These elements cannot be established by mere conjecture, guess, or speculation. To raise a fact issue on causation, and thus to survive legal sufficiency review, a claimant must do more than show a substantially elevated risk. And if there are other plausible causes of the injury or condition that could be negated, the plaintiff must offer evidence excluding those causes within reasonable certainty. The lead case on that is Merrill Dow versus Havner, which is also an expert case. But we also cite Martinez versus the city of San Antonio, which is a 2001 case out of the San Antonio Court of Appeals. We believe that the peelers have wholly failed to raise a fact issue on causation. Let's talk about their responses to damages. They essentially say in their response that proof of any injury to land, including stigma damages, satisfies the peeler's burden to prove damages. And so they point to their expert Bolton's report and say, see, we're claiming stigma damages, so we've created a fact issue on damages. This is, in our view, incorrect as a matter of law, as explained in the joint motion to exclude Bolton that was heard on December the 9th of last year. And I'm sorry to make it sound that long ago. It was just last month. The joint motion to exclude Bolton, in that motion, that the Supreme Court to date has expressly declined to approve stigma damages either way. I mean, as an available remedy or not. We believe Bolton's opinion should be excluded, and that this just mere pointing to stigma damages not sufficient to satisfy the peeler's burden. There are all these unsupported claims that all of the Peeler Ranch has been affected either directly by contamination or by the stigma associated with the contamination. There's no evidence of any damage, such as we couldn't use our property or a part of our property for cattle ranching, that has been raised in the motion in the form of summary judgment evidence, or raised in the response in the form of summary judgment evidence. And we note here two things: stigma damages for temporary injury that has been repaired, or is for temporary injury that has been repaired, and not for the permanent injury claimed by the peelers. Those claims are inconsistent. And the weakness of their damage claims as evidenced by their reliance on stigma damages as fulfilling their burden. Where is it? Where is the evidence of damages here other than in this appraiser's report, which we don't believe is competent? The peelers cannot collectively point to a single tract of land comprising the Peeler Ranch and say that something KMG did or did not do, that it owed the peelers a duty to do or not do, caused damages to it. They point to no evidence that allegedly polluted groundwater caused by KMG that is contained in an aquifer that always has been unusable in the first place due to high salinity, prevented any ability of the peelers to use the land as a cattle ranch or for hunting or for anything else. They also provide the court no competent evidence that a large part of the property they claim is worthless based on their appraiser's report, while at the same time on this property, they continue to collect oil royalties of multiple millions of dollars per year. I think most of us would like that deal. It's worthless, but I'm drawing those royalties.
Your Honor, again, I have to object. None of this evidence about royalties or how the peelers use their property or any of this, even the claim that we didn't prove the element of damages, is in their motion or reply.
But it's in our reply, Your Honor, and I'm pointing out evidence in argument that the peelers could have presented but did not, and instead just pointed to their stigma damages or their alleged stigma damages.
All right, I'll take this as just argument. Go ahead, Mr. Guthrie.
Thank you, Your Honor. I'm getting pretty close to being done. Let's talk about their response regarding standing. KMG has contested their standing in terms of ownership of the land at the time the alleged injury occurred or injuries occurred. And the peelers claim that property deeds that they attached to their response prove that each peeler counterplaintiff held an ownership interest in off-lease peeler property injured by KMG's acts and omissions at the time coal ash toxins entered the property. Transfer of the property among the peelers may shift the right to recover among counterplaintiffs, but does not extinguish any liability. And they say because the right to recover for KMG's torts and statutory violations depends in part when the various causes of action accrued compared to when the land was transferred. The accrual dates turn on issues of disputed fact, including if and when harm to the land became permanent, the question of which peeler counterplaintiffs can recover for what part of KMG's liability cannot be resolved through summary judgment. Well, that's all nice, but we move for a no evidence summary judgment based on lack of standing. So they have the burden of coming forward with some evidence of standing to prove that each of the peeler claimants have the right, or just to create a fact issue, that each of the peeler plaintiffs have the right to recover damages from KMG here. The peeler's position completely ignores the Exxon versus Emerald oil and gas case that we have discussed in this lawsuit before, that the court's familiar with. It talks about when a cause of action for real property accrues. And also stands for the proposition that a mere subsequent purchaser of the property cannot recover for injury committed before his or her purpose. The deeds that they attach are not certified copies, and they're not authenticated. They are not competent summary judgment evidence. They just slap copies of some deeds onto their response. So they fail in their burden to prove standing. And the motion for summary judgment should be granted on that basis. Now, they make some other arguments about continuing tort doctrines and accrual of the cause of action. We responded to that in our reply. We don't need to go into it here. Now, setting all of the peelers' responses aside, the fact remains that their experts do not base their opinions about contamination on state action levels. And I don't want to go through, and I'm sure the court doesn't want me to go through the Taco Cabana cases and the other cases that came after them. The peelers, I understand, disagree that Taco Cabana establishes the standard that requires an exceedance of a state action level or a protective concentration limit that's properly calculated. But if that is true, the peelers surely have not satisfied their burden here. In summary, Your Honor, KMG asks that the court grant the motion for summary judgment. As I indicated, we have a number of evidentiary objections. I don't know if the court would rather rely on a review of those objections, which are contained in our reply, as well as our motions, various motions to exclude the experts. If the court would like Mr. Schneider to walk you through those objections, but I am finished unless the court wants to hear those objections.
All right. At this time, I've heard enough for the moment. I've got to say, I'm not sure if I should be flattered or flabbergasted or what, that the attorneys seem to have so much faith in my ability to keep things straight in my head. I used to have a very good memory. It's now somewhat intermittent. The motion is 56 pages. The reply to Peter's response is 69. It also incorporates 609 pages of documents in 4, at least, previously filed motions for a total of 609 pages, 482 pages from other documents, for a total of 609 from the movement. And the response is 847 pages. And I didn't bother to count up how many pages the number of documents it incorporates include, because that's 1446 right there. And that's without even looking at the responses or the replies. So I'm not going to let Ms. Whittle, we're going to continue this, and I'll tell you what I'd like to see. This doesn't have to be fancy, and I absolutely do not want new briefing, new arguments. I just would like, and it could be as easy as an Excel spreadsheet where you have, here's on one side, paragraph number XYZ of the peeler's live pleading, and just a little, not more than about 4 or 5 word caption about what they're seeking there. And it might be better to ask the peelers to do this first, and just a very short caption, what they're seeking. Trespass damages for ash, whatever it is, and then a paragraph from the defendant movant, counter defendant, about what of your arguments you were referencing on that particular claim, because without that, I'm going to be left to either say I can't figure it out and just deny it on that ground, or trying to go through and look through the pleadings one cause of action or one paragraph at a time myself. So let me ask that kind of, and then I'll give Ms. Whittle a chance to speak before we finalize this. So let me ask you attorneys, I know that you spent a lot more time with this case than I do, and you have a whole bunch of things in your head that I don't keep track of because I keep having other things that I have to work on, and I'm sure you do too. But so would it be better for the movants firm to come up with the matrix, I guess, that I'm asking for, or the spreadsheet that says for each paragraph that you're responding to, and only the paragraphs asking for damages against KMG or your causes of action? You know, I don't have to have responses where you're admitting or denying any factual allegations or anything like that.
It's, Your Honor, if I can respond, it's probably going to be hard for us to characterize what the peelers are seeking in terms of what damages they seek for which violation. I mean, I'm happy to take a crack at that, but I'm afraid that's going to lead to some disagreements over the movement, the respondent side in terms of the claims. I think it would make more sense to have the respondent side set out, as the court suggested, what their claim is and what they're seeking, and then let us talk about what our grounds for the motion are.
Your Honor,
obviously the peelers would have to have an opportunity to put just a little bullet point caption. Here's the 1 or 3 grounds that we're responding to, or that we're saying. And you understand what I mean? Where I don't want new briefing, but I just want to be able to, I guess, have you marshal your arguments so that I know what you're arguing on each particular point or each particular claim for damages.
May I say what I think you're asking for, just so we're all on the same page? I think you've asked us to take out paragraphs that are in our current live pleading that are specific to Kiewit under each cause of action, and then put that in a table.
And I'm not even asking you to do that much. Just,
okay.
You know, paragraph 218, damages for trespass for water seepage. And I'll go back and look at the actual language. And I don't want to keep this simple on y'all's part. So that can just be, you know, column 1 of the Excel spreadsheet. And then have your Excel spreadsheet that has all of the damages you're seeking, just in a little tiny nutshell about each one. And then the defense can put their response in where they refer me to what their arguments are. And then I'll let the peelers put a response in where they refer me to their oral arguments, which I guess they would be doing before they actually had to make them.
Okay.
I'm trying not to. I'm not trying to run up the billing in this, so that's why I'm saying don't rebrief it. Just little bullet points.
And so you'd like us to reset the hearing on with our responsive argument to a later date?
Yes.
So at this point, Your Honor, we have had a lot of difficulty scheduling things, and my guess is that we would be unable to schedule that until March if we kept all the current motions in place. Do you have a preference about how long you want us to wait before we have this heard?
Sooner rather than later, it would be all. So my notes still mean something to me when I come back to them.
And do you want us to file this document, or do you want us to email it to Ms. Riley?
Email is fine.
I think we should try to reach an agreement on a sooner rather than later hearing date and possibly bump something else, postpone something else that's already scheduled for a hearing.
I think San Miguel will be happy to work with you guys on that. And I know Roger's listening, but we can all work together for that.
But what has occurred, Your Honor, is that all of the peelers motions keep getting kicked to like March. And that's what I would like to avoid, is having all of our motions continue to get pushed. So we will negotiate it, but we will try to do it as soon as possible.
Okay. And let me just post something, if I can find it and get it back to.
Do you want me to verbally say some dates that Judge Wilson's in court in February?
Well,
oh, sorry.
No, that's fine.
Okay.
Miss Riley, I thought February 4th wasn't available, but then I heard another matter this morning set for that day. So
that's with Judge Ellison's on that docket.
Oh, okay. Sorry about that.
Y'all are scheduled on the 9th and the 11th right now is what I have. I'm not sure what motions, but.
Can you tell us the dates for February again? I thought it was like the 9th, 10th.
The 9th and 11th are actually full already, but y'all are both on those dockets. The 10th, the 16th, 17th, and 18th. That's it.
And then can you provide us the February date and March dates, just so we know where we're kicking the other ones?
Sure, let me see. March the 8th, 9th, 10th, 11th, 16, 17, 18, 23, 24, 25.
Okay.
And that's it.
All right, thank you.
You're welcome.
All right, it wouldn't let me post what I want to post. Give me just a moment and kind of convert it to a PDF and see if that makes a difference. Yes, okay, I've just posted to you, this is from 2 or 3 years ago, a couple of years ago, a jury trial in Karnes County. This is just a page from something I made up to work on the charge, where I had started out with saying, what the claims were, what the answers were, and what issues I still needed to work on as far as the charge. Okay. So there was a 2-week jury trial that would boil down to just this 2 pages. That's the sort of thing I'm looking for.
And you want that for just our causes of action against Kiewit, not for any other party, correct?
Yes. Okay.
Judge, sorry
Yes,
to
sir.
add in, since I wanted to ask, since chances are I'm going to be helping with this too. In the chart that you sent, there's not cites to specific evidence or anything
Okay,
there.
this is something I put together working on the charge.
Okay.
But
is what you want from us?
A very brief statement of what the claim is. And you can even, instead of doing by every paragraph, I don't care if you break them down into sections, sort of like I did here. But
Okay.
something that could let me keep an eye on what the claim is, what the answer was, and this was just, I think, issues that needed to be, I needed to research for the charge.
But you don't want our chart to actually include the sites to the evidence and all too, right? Because that would end up being
No,
duplicative of what our
yes,
response
yes,
already.
no, that's fine, just.
Okay.
Okay. All right.
I'm scared we're going to mess this up, but we will do our best.
Like I said, this was a very long trial, or not very long, but it was a very large case with all kinds of claims and counterclaims, and I boiled it down to just these issues.
Okay. Thank you, Your Honor.
And obviously, I guess in a no evidence motion for summary judgment, the appealer's responses would probably be a bit more elaborate than this, but mainly I just want to be able to keep things straight in my head and look at them one at a time. All right. Anything else for today?
Nothing I can think of, Your Honor.
I think we've posted both of the both of the orders, the mediation order.
Mr. Guthrie, you didn't get them back, right? Because I never signed them because Mr. Guthrie sent them a second time and they're still corrupted. I don't know how. So Mr. Schneider, if you could post.
I think I downloaded whatever it was that was posted originally. So I guess the file was really corrupted.
Oh, well, it may have been a bad copy for everyone.
Yeah. I just sent you back what I downloaded. So, but we can get you the orders.
Your Honor, I'll try to get the order for the January 19th hearing real quick.
Yes, whenever I click on the ones that I was sent both at 9 o'clock and at 10 o'clock, it says Adobe Acrobat could not open order on January 19 hearings PDF because it's not supported or damaged.
Okay, I just posted that one and I will see if I can find the mediation one.
This one. Yes, this one opens.
Okay, and then let me see if I can do the other one.
And the attorneys had a chance to look at these?
Yes, Your Honor.
Yes, Your Honor.
I've now posted the order compelling mediation.
Okay, Chris, if you'll hold on a moment, ma'am, I will get these signed and filed and ask you to e-file them.
The judge's aware, so he knows your stomach.
Judge.
Yes.
I'm going to take a quick break.
Okay, I think we're finished with you.
Okay. Thank you, Judge.
Judge, were you talking about just the stuff that you're going to post?
Yes, I'll get those in just a moment. I just downloaded them.
Yeah, because I saw a few, but I didn't know those were for you or if that's what I needed to download. So I'm just going to look for the ones that are coming from you, right?
Yes, ma'am.
Okay.
Okay, I've just posted those two orders to everyone.
Okay.
All right, then I will leave the meeting running for a while for y'all to be able to have a chance to download them. And after that, everyone's excused.
Thank you, Your Honor.
And it was just 2 for
Good.
me, right, Judge? Or actually 3, it looks like from you?
Well, just two, no,
Okay.
just one of them. The other one is just for the attorneys to look at.
Okay.
Yours does need to be filed. Okay. All right. Y'all have a good Friday.
Thank you, Your Honor. You too.
Judge.
Yes, ma'am.
Thank you. I wrote down the dates for February and March so I can send it around to whomever. I guess everyone's leaving. Bye.
Bye. All right, and Ms. Benavides, do you have the orders downloaded?
I'm just looking at them right now, Judge. Let me make sure the second one came through.
Yeah, I make sure they work. That's what I keep
And
having.
Judge, just an FYI, Jennifer said there's a meeting at 1 o'clock tomorrow. She was going to set that Zoom up. She did set it up, and then that one case was reset to 1:30 tomorrow. Do you want me to push that back to 2 o'clock and let them know?
Please.
Okay. I'll do that.
No, I shouldn't need to be that long.
You don't think so? Okay.
Training. I just need to show the flag. That's
Judge,
fine.
and I got them, Judge. They downloaded
Okay.
just fine.
All right, then I'm going to end the meeting.
All right, and I'll be out tomorrow, Judge, so just FYI.
Okay, and I've got the 11
What-
o'clock.
Can you hold on 1 second? I think Jennifer wants to ask something.
Does he want me on an 11 o'clock meeting?
Do you want Jennifer on the 11 o'clock meeting?
No.
That's at okay. No.
No, because if I do, that people will be trying to volunteer you and
Okay.
someone in the office to help the JPs get this set up, and that needs to be the IT people for every county.
Okay. All right, Judge. Thank you.
Okay.
Y'all have a good
Thank you,
day.
Judge.
You too.
Bye, Lachey. I'll send you that invite here shortly after I get it set up for tomorrow. Take care.
And Lachey, you don't have to be at those other two meetings, just the court.
Just the court. Yes,
Yes.
1 o'clock.
1:30.
1:30.
1:30.
I've got an 11 and a 1 also, but you don't have to be at those.
Okay.